PM list item 43. Today I have collected the PCR in my pen drive. May I play next week or one
Which item?
Item 43 of 2 PM list.
No, you mentioned at 2 o'clock.
But
Supplemental list, item number 1.
May I please alert, sir? My lord, last occasion, the State Council, my lord, submits for time to take instruction, my lord, on in terms of order passed by this honorable court on 37/2024, my lord.
But there is no legal impediment to settle the land and the compensation to be paid. She may grant me some more time. That I'll-
This 28A problem is that the court has to decide. Asking the officer that what is the merit, what will they do? The court has to decide. It is a legal proceeding.
It is a legal proceeding.
Representation will be disposed of. How can you
Yeah.
decide?
This letter which was written on 22/11/2022,
23.
that is by
I have 3 reads.
Special
The
LA
claim is
and
there.
Lower Irrigation Project Kharia,
Yes, ma'am.
and it was found that your claim is genuine
Genuine.
and petitioner is entitled to higher compensation
After
Yes,
20.
under section 28A as per the judgment of the Honorable Senior Civil Judge Nuapada in LAR number 1. So that was forwarded to you and you have to just carry out it. That is exactly the order of which we passed
On
on
37.
that recommendation has been made on the basis of the
Yes.
judgment passed by the court,
Yes.
and yet no disbursement has been made.
Calculation sheet also there in.
Yes, yes. So, and 23 we are in 25.
Hiroshima, can we some more time? I'll see to it. I'll take instruction whether what is the further progress in the new.
The first order was passed on 37/2024.
It is already
Grant me 4 weeks time so that it can be.
hmm.
Hiroshima, grant me 4 weeks time so that.
No, you have already taken more than 6 months time. The
One
first
last-
order was passed on 37/24.
Yes.
So more than 6 months have been passed.
Or one last chance maybe given so that I can apply.
You cannot guarantee 4 weeks. Who is this opposite party number 4?
Your land acquisition of
OP
OP number 3.
number 3, ma'am. Number 3.
No, this the order which we passed on
OP number 2,
the first order.
Yes, ma'am.
OP
number 2.
OP number 2 is to make the disbursal of the amount.
Director R&R from ex officio.
That is the letter from opposite party number 3 basing on the court judgment of opposite party number 2.
Yes, yes.
So opposite party number 2 is the
Person to take a
person
decision and
to take a
disburse.
decision and disburse the amount.
Yes.
And 6 months have already passed.
Can I prefer these 2 weeks time?
Like 10th March 2025.
Much.
The Land Council for the state 2 weeks more time. To obtain instruction from the opposite party number 2 in terms of the order dated 37/2024. The Land Council for the petitioner objected to such adjournment on the ground that more than 6 months have already elapsed since the date of the first order was passed. Be that as it may, is this matter on 10th of March, we commencing from 10th of March 2025, it is made clear that this court shall not grant further adjournment to the land council for the state for the purpose of taking instruction from the opposite party number 2. Yes.
Please.
Item 2.
Here the petitioner is the ex-employee of Ralph Steel Plant Mill. Here we are challenging the notice dated 14/9/2024, page 47. The opposite party number 4, wherein directed to vacate the unauthorized construction within 3 months, Miller. Otherwise, they will remove that. Annex 8, Miller, page 47. The fact of the case, Miller,
14/9/24.
14/9/2024.
Yes.
That is page 47.
So that 3 months period has already expired. There is no stay order.
There is no stay order. 3 months are already
So,
expired, Miller.
Might have been.
Now they issued another notice to vacate that premises.
Where is that? You come to the last portion of that page 48.
Yes, Miller.
The last paragraph of
Yes.
the input
You are here.
notice of termination. That is, you are here. You read it out.
3 months, Miller.
No, please read it out. That portion.
You are therefore called upon by this notice to remove unauthorized construction made in violation of sublease conditions within a period of 3 months from date of receipt of this notice and report compliance, telling which on expiry of 3 months notice period, the may sell Ralph Steel Plant shall be left with no other alternative but to terminate the sublease and re-enter premises. In such event, you shall hand over the vacant portion of the premises to MS Shell Ralph Steel Plant forthwith by depositing your due and accrued toward rent.
So that period has already expired.
Yes, in time I filed writ application. That writ application listed before the Honorable Single Judge.
There is no interim order passed. It was listed on 24/12/2024 before a Honorable Single Judge.
Yes.
But no order has been passed, interim order.
So, no interim order, there is no assignment, no interim
that order has been, the time period has already expired.
And other connected matter, the difficulties, Miller, SR point out is a division bench matter.
Whatever it may be, that period has elapsed. So they might have taken the,
have
terminated the sublease.
Now, yesterday another notice is issued and connected.
No, those matters are not before us. Whatever you are telling, that is on the basis of your oral submission. If you say that for 3 months, after 3 months,
the mistress already I have ready to my mistress with me, Miller.
You keep it ready with you.
Yesterday,
we presume that the action has already been taken in terms of the notice under Annexure 8. But if you say that no action has yet been taken,
no action has been taken. Yesterday, the short notice. Just now, mistress will ready to
do one thing.
In connected matter, this Honorable grant stay, Miller. In similar matter, the same notice 14/9/2024. Also, may peruse that notice.
The Land and Council for the state shall obtain instruction.
The state is not the contesting. State is not the contesting party. Steel Authority by RSP is the contesting party. It is the Petition as well as the quarter of the RSP.
You have already. The present IU which you want to file?
Stay the notice dated, my lord, 19/2/2025.
No stay. That period has.
challenge करना stay का.
And सेटा काली दले आमु notice टा मिस्टेक ready, my lord. In same notice has been stayed, my lord.
On what ground you want that the matter should be, the notice should be stayed?
My lord, the lease, my lord, I enter facts, my lord, clarify.
No, where is the paragraph?
My lord.
Which is the paragraph you say that what is the defect or the illegality in issuing notice to you? They have given the reasons why
yes,
they are.
This Steel Authority of India itself, it is a scheme for regularization of unauthorized construction. Annexure 4 of CMC.
You come to that notice under Annexure 8. Read it in entirely. Read that from page number 47.
Dear sir, during the period of her working as an employee of Shell, Ralph Steel Plant Raulkela, you were allotted him company's pattern number such and such, sector 2, under a sublease, subsequently pursuant to sale scheme for leasing of houses to the employee 2003, a tripartite sublease agreement in respect of the said house was executed on 13/11/2009 in your favor for a period of 33 years, with effect from 29/4/2004, and said sublease agreement was duly registered on 24/11/2009. Your possession over the demise premises is governed by the terms and conditions of the sublease agreement, under which any additional construction, modification, structural alteration is not permissible without prior permission writing by the sale RSP. It is further stipulation that in the event violation of such aforesaid condition, RSP shall have a right to terminate the sublease and re-enter into premises. The permission accord, Miller.
Please read out.
It is noticed that in gross violation of the terms and conditions of the sublease, you have made one additional unauthorized RCC structure of about 1041 square foot as against approval area of 603 square foot, that is 438 square foot, in excess to additional unauthorized temporary structure asbestos plus tin roof of about 281 square foot, excluding staircase area, and 3 unauthorized vertical structure of about 476 square foot on sublease premises, for which you have neither obtained any permission nor approval of building plan from RSP as per its procedure. Furthermore, these constructions are beyond 40% norm, that is, the total construction including the original structure should not exceed 40% of the sublease area. Also, you have encroached upon RSP land measuring about 61 square foot. Details of aforementioned unauthorized structure and encroachment are attached herewith below. I have applied for permission. Then you are issued notices for courts on 10/1/2024, and your reply to said notice has not been found satisfactory.
Yes, then.
Then please note that although in your application for grant of sublease under the scheme, which norms part of the sublease agreement, you have undertaken to avoid the terms and conditions and declare to be liable and cancellation of sublease in case violation. You neglected and failed to remove the unauthorized structure in spite of aforementioned notice below.
Yes.
Lordship, the petition applied for additional construction. That has been approved. Lordship may see the annexure.
So that they said not more than 40%.
40%.
So that they are saying
That is
beyond.
the introduced scheme for regularization. That is annexure 4, Lordship.
Petition interpretation is that 40% beyond the existing structure.
Because of the comfort.
And
Lordship,
RSP's interpretation is that 40% in total.
Lordship, turn to page 38. Their scheme for regularization.
Annexure?
Annexure 4, page 38.
Yes.
What is this?
That is a regularization of unauthorized construction. With the effect from Lordship, Lordship, see the page 38.
What is there?
The sale scheme for regularization of unauthorized construction of lease houses.
Yes.
That is with effect from that decided on 20th August 2008, and that scheme has been effect from 2009, Lordship.
You come to 2.7.
Yes, my lord. If the lease does not apply for regulation, unauthorized construction is more than the area permitted under the scheme, lessor shall, name of the plan, shall take suitable action as per the lease terms of leasing scheme, including the cancellation of lease, demolition, and construction of the leasing cost.
Which may kindly see clause 3.2 at page 40.
2.2.
3.2 here.
3 point.
3 point. Page 40.
Hmm.
In 2002, following addition, alteration, modifications are permitted in the leased house, and these are the permissible limit. After that, the notice was issued, which is that which is at page 44, Your Lordship.
44 is the
Page
scope of the
40,
notice.
so first paragraph.
No, how do you say that if they have got a certain limit as it appears, but beyond that it is not permissible?
And they have not taken into consideration of their scheme.
No, because it exceeds that. They have stated that it exceeds that. You see, they are stating that it exceeds 40% or something like that, they have stated.
This scheme was valid till when?
Since 2009, ma'am.
Not since. They said there is a
No,
certain
Ashim, ma'am.
period. No, God.
No, Satare, it's like the scheme that has been considered a full regulation of the construction release at not everything. At the page 39, the scheme is called Shell Scheme for Regulation of Unauthorized in the Leased Houses. This is one-time effort to regularize unauthorized construction in houses, lease and sale scheme for the leasing houses to the employees,
Yes.
implemented during 2001 2003.
ଯାହା ଥିଲା ତେଣୁ ସେତିକି କେବଳ କରିବା ପାଇଁ ଏଇଟା ଗୋଟେ ଆସିଲା ସ୍କିମ୍, ନଟ୍ ଦ୍ୟାଟ୍ ତାପରେ ଆପଣ କେବେ ନେଲେ ଲିଜ୍?
1993 our agreement was executed 2004.
ଆପଣଙ୍କର ଏଇ କନଷ୍ଟ୍ରକ୍ସନ କେବେ ହେଲା?
2.3 ଟା ଦେଖନ୍ତୁ.
Construction at 2009.
The regularization of unauthorized construction shall not be considered after closure of the scheme. ଦେଖିଛନ୍ତି କୋଉଠି ସ୍କିମ୍ ଟା କେବେ ଯାଏ valid ଥିଲା?
Lordship say top at 39.
Yes.
The scheme shall come into force with effect from 1st September 2009.
ବୁଝିପାରୁନାହାନ୍ତି question ଟା କଣ ପଚାରିଲି ବୁଝିପାରୁନାହାନ୍ତି? I read out clause 2.3.
Yes.
Yes.
ମୁଁ 2009 ରେ after scheme ପରେ ମୁଁ approval ନେଇଛି.
The regularization of unauthorized construction shall not be considered after closure of the scheme. ମୁଁ closure କଥା ପଚାରୁଛି ଆପଣ କେବେ start ହେଲା ମତେ କହୁଛନ୍ତି? ବୁଝିପାରିଲେ?
Yes. Scheme ଟା ଛାଣିଲା effect from 2009. 9 ରେ scheme ଆସିଲା ପରେ ଆମେ application ଦେଲୁ additional construction. ସେଟା approve କଲେ ସେମାନେ ମୋ additional construction. Annexure 3 page 35.
That drawing is not enclosed. Basing upon which the constitution has been used. The drawing has
Taking
not.
for granted.
It is not, there is a period stipulation we are not finding out actually. This scheme was formulated because there were already unauthorized construction, and to regularize it, they have given this scheme, and that was for a particular period. And after that, you have to apply it, and if they think or they found that it is within the prescribed limit, they will approve it. Otherwise, the other part is to be liable to be demolished.
उसमें page 35 annexure 3. After scheme introduced, I applied that 29/10/2009.
Thereafter, they have issued you. They found that it is also in violation of that. So that is their letter as if they are aware of that. But you have not done as per that. 40% you have exceeded.
Where is your so-called notice 10/1/24 and where is your reply?
Page 45. Lord.
Yes.
Encroachment was permitted by RSP.
Madam?
Encroachment was permitted by RSP on the beyond your compound. That also you can make construction wherever you find RSP land, you can do.
No.
We understand, subject to correction, that you have been given a plot of land along with a house. You have made some additional construction. For that, you have, as per the scheme, you have applied. But beyond that, you have encroached on the RSP land. That is what the show cause notice from the very beginning.
It's not never applied under
3,
the scheme.
4, 5 things. Not under, never applied under
Never
the scheme.
applied. It was always the reply to the SOCO's note.
No, there is that permission.
That permission, kindly read for a moment.
Copy of the permission letter.
Kindly see
14/12/2009 and page 35.
Page 35, first paragraph. May I read? With
Yes.
reference to your application dated 29/10/2009 on the subject cited above, we would like to inform you that the management of RSP is
Oh yes,
pleased
where
to
is the
grant
application?
permission.
That was as per the scheme, or you had asked for construction and thereafter you have done whatever you
May I read it?
Yes.
RSP is pleased to grant you permission for additional construction, modification, etc. as per plan drawing enclosed the following terms.
Had you done that, there would have been no question of asking for.
The drawing is not in.
You are right, right. Neither the drawing nor the application.
Yes. Kindly see page 45, paragraph 2 for it.
Yes.
May I? This is the petitioner's interpretation as to the modification is not cross the permissible limits of extra construction as alleged. As per the information obtained through RTI from the RSP authority, I am entitled to construct 60% of the total area, including the existing original structure, which comes to 2226 square feet, which is much more than the RCC area, even taking into account 230 feet of temporary construction. It is not exceeding the limit. Besides, temporary structures are not to be taken as extra construction as they are temporary in nature. As per the information obtained through RTI from RSP, I am entitled to additional construction of 40%. This additional word is not there in the RTI information.
And you have also not stated in the application anything about this regularization thing. So that means you are not covered by that.
They have never applied.
Look at your show cause reply. Annex year 7.
Yes.
Yes.
The question is whether they come under that scheme or not. That is the question.
Suppose the additional 61 square foot I have enclosed. That is the 61 square foot. That is including entire square foot.
Cannot be.
3710 square foot.
That is additional land. You have been given original lease. You have encroached beyond that.
They are saying that beyond.
So, who will say?
Counter, they will say, Lordship,
but what is wrong? What is wrong with that order? We can't.
I'm asking you. It's not a formality of issuing notice. We have to be satisfied before issuing notice to an authority. What is the fault in that order? So by this process, you would say that the REIT has been entertained and we'll spend there 20 years. And
they have to also maintain traffic and uniformity in that area. That is why these rules are there.
that 3 months period has expired in the meantime, and whether in terms of that last 49 your sublease has not been terminated.
Yesterday some notice digital option I am ready to discuss with you.
The writ petition has been filed by the petitioner Pinath Patnaik, challenging the notice dated 14/9/2024 issued by the senior manager Land Town Services Department, bracket opposite party number 4, wherein the petitioner was asked to remove the unauthorized construction made in violation of the sublease conditions within a period of 3 months from the date of receipt of the notice, and to report compliance, failing which, on expiry of 3 months notice period, Messrs. Sale Raukala Steel Plant will be shall terminate the sublease and re-enter the premises, and the petitioner has to hand over the vacant position of the premises to Messrs. Sale Raukala Steel Plant by depositing the dues as accrued towards rent, service charges, electricity and water charges, etc. Since 3 months period as stipulated in the notice under Annexure 8 has already been expired, when we put a pertinent question to the Land and Council for the petitioner as to whether follow-up action as per the aforesaid notice has been taken by the authorities or not, he submitted that the petitioner has received a notice yesterday and he wants to file an affidavit annexing the notice, giving copy to the Land Council for the state, and the matter may be taken up next week. Put up this matter in the
Sale is the contesting party.
Huh?
The
Will you
water
file
belongs
the-
to sale.
file the-
Radcliffe State Land.
I filed the interim application for them. Put up this matter on week commencing from 3rd March 2025. Service of notice 3/3/2025. Yes,
Must be interim order Miller. Tomorrow is the
sorry. Yes, next.
Item 3.
Item 3, my lords, order dated 23/12/2024. I have to take instructions of obtained instructions. Unfortunately, I had called for 4 copies. He has given me 2. He gave 2 copies.
On 16/1/2025, there is an order that if instruction are not received
They received.
by 4th February 2025, this court shall take coercive measure in accordance with law.
I have
So,
the instruction. It's just that, my lords, unfortunately, I had called for 4 copies. I have been given 2. I'll give 2 more copies. I have the instruction.
what is the instruction?
My lord, there is alternative remedy available under section 38A and 38B.
Which order is challenging you now?
Order of the Tahsildar.
11/2/2022.
Miles. Instructions, my lord, had sought on 2 issues. First one is whether there is any alternative remedy to assess the impugned order. Second one is whether the petitioners have been noticed in OEA case number 272.
What is your instruction?
Subpara 3, my lords.
Yeah, notice has been issued.
Notice was issued to the petitioners on 21/12/21 to appear in the court of the undersigned on 21/22 for hearing of the OEA case number 272 of 2017. The notice was received by the wives of the petitioners, namely Chakradhara Mahapatra and Govindra. One copy of the said notice is enclosed in this letter. The petitioner may file appeal before the ADM's collector as per para 3, 11 and 12 of the GO number 3776 dated 2/2/2017 or section 38A and 38B of OE Act. My lord, may kindly have a look at the genealogy in the last page
Genealogy?
of this entire matter, how this property has devolved and the averments taken in the writ petition. Why I say so, my lords? My lords, may kindly come to para 8 of the writ.
Read.
My lords.
Here.
Para 8, my lords, the last line. So from both the documents, it appears that late Vikari Ponda had 3 sons, namely Ramachandra Ponda, Gajendra Ponda, and Kalandi Ponda. That is his averment in para 8. In para 12, the document kindly come to para 12. Humbly submitted here that Vikari Ponda died leaving behind 4 sons. In the name of Ramachandra Ponda, Gajendra Ponda, Kalandi Ponda, and Joram Ponda. In one averment, he says 3 sons, in the other one, he says 4 sons. There is no legal heir certificate. There is no succession certificate. That is why that genealogy becomes important, because we have 4 different kinds of how the property has devolved or should have been devolved according to the rate, according to inquiry.
But there is an alternative remedy.
My
It is said.
Yes.
देखिए वो ये था देखिए.
38A, my lords, will find the review provision in the OEA.
Yes.
That's 38A, my lords,
Yes.
any decision made or order passed under this Act, whether before or after the commencement of the Odisha Estate Abolition Amendment Act 1973, other than a decision or order against which an appeal or revision has been referred under this Act, may, within 1 year from the date of decision or order as the case may be, and after giving all persons interested an opportunity of being heard, be reviewed by the officer who made the decision or passed the order, or his successor in office, on the ground that there has been a clerical arithmetical mistake in the course
This
of
is other than a decision.
My lord.
If appeal and revision is not there, then this review will be applicable. The
Revision is there.
bracket portion that is important. Other than a decision or order against which an appeal or revision is preferred on the other. So, according to you, if the appeal is maintainable, there is no question of filing a review petition. Or if a revision is maintainable against the order, then also the review is not maintainable. That is how it is stated that other than. So, appeal what? There is no appeal. There is a revision or what? 38B.
Just a minute. Only on the ground that arithmetical clerical mistake.
That is review scope.
Why I say so? Because of there is no certainty as to how this property has devolved according to the petitioner himself also.
No. Under review is maintainable only for correcting arithmetical mistake or clerical mistake. So how will this be covered under that?
No, the revision scope is little broad than.
He's taking 38A.
38 yes, 38 এটা বহুত limited है ना. Except clerical and arithmetical mistake during the proceeding. 38B
is broader.
Please read it out.
The Board of Revenue may on its own motion or on a report from the collector call for and examine the record of any proceeding in which any authority subordinate to the Board of Revenue has made any decision or passed an order under this Act, not being a decision against which an appeal has been preferred to the High Court or the District Judge under Section 22 for the purpose of satisfying itself as to the regularity of such proceeding or the correctness, legality, or propriety of such decision or order. And if in any case it appears to the Board of Revenue that any such decision or order ought to be modified.
So this is broad definition. But 38A would not be applicable because it is only for a limited purpose. What do you say?
It's not appeal will be.
Huh?
Appeal.
Appeal provision code achi.
22, my lords, is appeal.
22. Let us come to that also.
No, 22 is for specific purpose. 22 except
22 re kon achi appeal provision.
22 subsection 1 says that an appeal under section 21 shall lie to the High Court if the appeal preferred involves a claim exceeding 10,000 rupees. The respective district judges to be notified in this. We have
just sorry for interrupting. First look at 21 and then go to 22.
An appeal shall lie against any decision of the claims officer under section 20 within 60 days of such decision in the manner provided in section 22.
So is this a decision of the claims officer?
With the claims officer.
This is not a decision of the claims officer.
Exactly. So he filed appeal and
claim officer definition is the claim officer is appointed under subsection 1 of section 18. So
secured creditors and maintenance holders. Revision is a better rule. This is a limited.
This order has been passed by Tahsildar Kishore Nagar. And what he has observed in the impugned order, that is 11/2/2022.
They said that The case record is put up before me today. My spot visit carried on 9/2/2022 and finding mentioned in Form D attached to this case record. Gone through the Hal Sabik correlation submitted by Amin Hal Khata of the year 1977, Khata 238, plot number 1365 by 1467, corresponding to Sabik Khata 1930, Khata 109, plot number, all ROR copy are attached with this case record. As per Sabik record 1930, Khata 109 was in the name of Jamidar Vikari Ponda and others. As per HAL records 1977, Khata 238 is in the name of Kalandi Ponda, son of Vikari Ponda, Sankar Ponda, son of Mahaswar Ponda, caste Brahmana, village Raghunathpur, and the scheduled land, that is plot 1365 by 1465, acre 0.21 in Khata 238 of Moja Siuli, transferred from Gajendra Ponda, son of late Vikari Ponda, Radhesyam Ponda, son of Jayakrushna Ponda, to Chakradhara Mahapatra, Govinda Chandra Mahapatra, Pramod Mahapatra, son of Jairam Mahapatra, by registered sale deed number 2356 dated 17/1987. And the vendee is claiming the scheduled land to be settled in favor of them, but the vendor is not here. The vendor here is not the recorded tenant of Hal Khata 238. That is, Khata is in name of Kalani Ponda, son of Vikari Ponda, and vendor is Gajendra Ponda, son of Vikari Ponda. And tenant Sankar Ponda, son of Mahaswar Ponda, is not vendor also. And the recorded tenant's name is not matching with the vendor as in the registered sale deed. Hence, from the above facts, the scheduled land is to be taken to the government khata. It is Abhada Jogya Honor.
So this cannot be, this is not, this will not come within that claims, as you say, prefer an appeal.
There are a lot of disputed facts.
Right. Instruction.
Advice
Yes, member board will be.
This writ application has been filed by the petitioners Chakradhar Mahapatra, Govind Chandra Mahapatra, and Pramod Kumar Mahapatra, challenging the order dated 11/2/2022 passed by Tahsildar Kishore Nagar in OEA case number 272 of 2017. Wherein the Tahsildar has ordered the scheduled land to be taken to government khata, that is Avada Jugya on Avadi khata. After arguing for some time, the land counsel for the petitioner seeks permission to withdraw the writ petition to approach the appropriate authority in accordance with law. In view of such submission, writ petition stands disposed of. It has also taken into court for the instruction agent for order dated. As per the order dated
23/12/24.
23/12/2024, the London Council for the State has obtained instruction from Tahsildar Kishore Nagar dated 17/2/2025, which is taken under the separate.
And I pray the certificate may be written on substation charges. Certificate copy of the
certified copy. Annexure 1.
Annexure.
The certified copy of the order dated one so be returned to the Land Council for the petitioner on being substituted with a 2 copies. Xerox copy.
Photostat,
attested copy. Okay. Yes.
Item number 4, SLP was dismissed, madam. SLP dismissed.
No.
Batch case.
It is a contempt petition which has been filed. It is a second contempt petition.
My lord, second contempt.
So, what was the order passed in the writ petition?
Page 33.
Huh?
Page 33. Relevant.
33.
Page 33. 2.
33 percent. Yes, 33 upon
Seventh line from the bottom is the opposite parties are directed to pay the financial benefit to the petitioner for the period from re-engagement till re-engagement as mentioned above in the sentence. That was the
Who has filed this writ? This petitioner.
Writ petition.
this petitioner along with other.
No, this writ which he has annexed. It is of Kailash Behra.
Yes.
And petitioner is Kailash Behra.
And this is the common judgment.
Okay, it's all right.
Three cases.
So now this order was not carried out, for which you filed the first contempt petition. So what order was passed in that first contempt?
First contempt.
Where is that order? They have been given some time to
let the opposite party comply with same.
Page 10.
Page 10. Page 10.
If not already complied within the meantime, within a period of 3 months.
3 months, yes.
Expiry of 3 months, filed the second contempt.
What you are saying that SLP has been...
SLP was dismissed.
SLP preferred by the state was dismissed.
Or state has been dismissed.
Yes.
Where is the order? Yes, the number is there. Petitioner number WPC number 6278, dated so and so. Dated on after hearing so and so, so and so. So you are to obtain now instruction that you are to carry out the order. There is no question of further adjourning.
Madan Chandra Nayak, first petitioner, Madan Chandra Nayak.
No, we are on this content petition.
Yes.
We are not going here and there.
My lord, adjourn to 3-3. Adjourn to 3-3.
Take up similar matter.
Similar matter. Common judgment.
अच्छा, common judgment. केबे रही जरा?
3-3-2025.
कौन order रही है?
Specific instruction.
This writ petition also reflected. Last line.
But other petition of ना change होगा, writ petition change होगा, content petition change होगा, है ना? बाकी SLP number से रहेगा, ठीक है ना? Also रहेगा.
Same SLP or that also is a batch?
Batch 3टा कैसे थी?
SLP
कैसे order है ना?
14485 to 14400. 3टा 4टा SLP 8586.
You are Mr. Barik or Mr. Das?
Mr. Barik.
हाँ. इधर क्या बात है ना? We are not keeping on the same date because they have to get specific instructions. तब फरे आसीगले जाना पड़जिबो.
Yes, next.
Item number 5.
My pleasure. In this case, inadvertently in the Annex 3, that I filed a wrong document. Actually, the section 12 application has to be annexed. Instead of that, I filed the section 32 application. The immediate question is the settlement of...
What do you want now? You have filed a wrong application.
Under
what do you want?
You have filed application of one Gokul Ananda Mahanti. You have filed of one Gokul Ananda Mahanti. Annex 3 to?
I may permitted to withdraw file a better application.
File a memo to that effect.
My letter.
The land counsel for the petition has filed a memo.
Pambitra.
Let's wait. A writ petition has been filed by petitioner Vijay Lakshmi Panda for such and such. He files a memo. Memo is taken on record, disposed of, and giving liberty to the petitioner to file a fresh one.
Certified copy কিছু আছে দরকার?
না,
Item number 6. But the petitioner, in the light of April and the month, he has filed this application challenging the order dated 1/11/24 passed by the Revenue Divisional Commission Court of that is next year
9.
9.
That is two orders which are included in the present application. This last order 1/11/2024 is not annexed. It's not there in the record. Correct?
There that is on.
The 1/11/2024, which is under challenge, it is not there on the record.
He has not solved a copy of that.
Check page 33.
Page 33.
They have given the last page of the certified copy and then the impugn order. Okay.
That was after the
Yes.
This is the order. Yes.
Please place that order.
Yes.
1/11/24 you are challenging.
Yes. The case record is put up today. The AGP is present for this step. The counsel for the petition is absent. Last chance for appearance was ordered on 6/9/2024. For today also, petitioner, counsel for petitioner fails to appear. Hence, case is decided as per bench and the record submitted. It is seen from the impugned order of the collector that additional Tahsildar by order dated 25/2/22 had resumed the lease out land under Section 3B of the Ujjalis Act on ground of not possessing the same and the land lying vacant. No proof of payment of salami has also been produced before the collector. On the above basis, collector had dropped the case as not possible to issue quota in favor of the appellant by the impugned order. Hence, the order of request for notice. So that's 25/2/22. That is 2002. That is wrongly mentioned there. That is mentioned the order dated 25/2/22. That is 2002. 2002. That is wrongly mentioned.
No.
Resumption of the order was.
No, you are not present. He produced the record and decided the case.
But it had like this. But in 2016, personal lordship direction, I filed appeal there. In appeal, in each date, I present that I filed my counter.
You cannot.
I
have no documentary proof that on each date you are appearing, but because you have filed only one order sheet, which is impugned in this case, and the revenue RDC mentioning that repeatedly you are not appearing.
Repeatedly, but government was
last chance was given to you.
2016, but I am present there.
Where
and
is the order sheet? Where is the order sheet?
Order
It is
sheet
a case of the year
34,
2016.
You have only given of 2024.
Yes, ma'am.
Appeal is of the year 2016, and now you are submitting that regularly. I was taking.
I filed my WS also. Government was specifically directed. Yes,
Whatever you say,
yes, that is documents here. That is the order sheet.
Order sheet should have been there.
But government did not file it. WS pilot. I filed WS. Record was called for, but record was not. It never come pilot. Order was passed. That is your problem. And the landless man, government is specifically directed to produce records. Records are produced. And in my absence, because the husband of
again on 6/9/2024, it stays case record is put up.
That is the.
So that is wrong. So that is wrong. You were not there on that date.
No, that is not wrong. But I was absent because the petitioner husband died.
କାରଣ ପାଇଁ absent ଥାନ୍ତୁ ଆପଣ ଯଦି କହୁଛନ୍ତି ତା ପୂର୍ବରୁ ମୁଁ ବହୁତ ଥର
every date sir.
Order sheet ଟା produce କରିବା ପରା କହିଲେ.
That is in your favor, but you should convince us that it is correct.
The petition has been filed by the petitioner Sarojini Mahanti, challenging the order dated 1/11/2024 passed by the Revenue Divisional Commissioner, Central Division, Qatar, in OGS Appeal number of 2016. In dismissing the appeal, in the said order, it is mentioned that the counsel for the petitioner was absent on 1/11/2024 and last chance of appearance was ordered on 6/9/2024. But in spite of such order, there was no appearance from the side of the petitioner. Accordingly, the Divisional Commissioner, opposite party number 2, perused the impugned order and was not inclined to interfere with the order of the collector. It is the contention of the learned counsel for the petitioner, Mr. Patnaik, that after filing of the appeal in the year 2016, the appellant was regularly taking steps in the matter and he wants to substantiate the submission by producing the certified copy of the order sheet in OGLS appeal number 2 of 2016 and pays for an adjournment. Please this matter keber rafiyom.
But 2 weeks after election, I will apply.
2 weeks after 17 तारीख ఎప్పుడు దిగాను మార్చ్ మాసం ఇట
Sorry. Yes, I will apply that.
अब अम्मा को
So,
अब
20
मना को अप्लाई करियो
Let it to 24.
आज raise this matter on 24th of March 2025. Yes.
Action number 7.
Right, please. In this case, the petitioner and this petition seeking a direction will also to direct Tahsildar OP number 5 to dispose his application, his miscase 13 of 2020 under Annexure 3 for correction of ROR as per the order passed by the ADM matter in Somoto revision case. ବର୍ତ୍ତମାନ କୋଉ ଷ୍ଟେଜରେ ଅଛି ସେ? ବର୍ତ୍ତମାନ ସେମାନେ ତ କିଛି କରୁନାହାନ୍ତି କିନ୍ତୁ actually 2007 ରେ ADM direction ଦେଇଥିଲା to correct the ROR. I have put it the order number. ନାଇଁ लीज ମିସ୍ କେସରେ ଆପଣ ପ୍ରେୟାର ହଉଛି to expedite to dispose of the lease case number 13 of 2020. Inquiry ପାଇଁ ଯାଇଛି ସେତିକି
Have you given us the order sheet saying what has
order sheet ନାହିଁ କିଛି ମାନେ କଣ order sheet maintain ହଉନି maintain ହଉଛି ମୁଁ ଆଣନ୍ତୁ କଣ ହେଇଛି ଦେଖ ଅଛି kind of stipulated period kind of mutation correction you will not be appearing before the authority on the date fixed and that may be the reason for delay of the disposal. So why the authority will be this type of petition would be entertained? Sorry, madam, I understood. You'll also kindly see page 19, annexure 4. ସେଠି ମଧ୍ୟ correction ହେଇଛି ଓ ଆପଣ factual aspect କୁ କାଇଁ ଯାଉଛନ୍ତି ଆପଣ ଗୋଟେ particular case କୁ ଚାହୁଁଛନ୍ତି dispose of କରିବାକୁ earlier ଆମେ ଚାହୁଁଛୁ ଯେ 2020 ରେ ଫାଇଲ ହେଲା ପରେ ଆପଣ all along steps ନେଇଛନ୍ତି but it was on the latches of the authority concerned for which delay has occurred. But if the delay has occurred because of you, then why will pass the order? To substantiate that, you have to file the order. Date Tahsildar prior Tahsildar transfer होची date
Samantra, if you give us the certified copy, it will be clear. We'll also know what stage it is at, so that accordingly we can fix the period. So get us the certified copy of the order sheet.
And produce my other logically 6 months, at least 6 months is the largest for mutation. The writ petition has been filed by the petitioner Janardhan Pradhan for a direction to the opposite party number 5, Tahsildar, Bhubaneswar, for disposal of lease miscase number 13 of 2020. For early disposal. The land counsel for the land counsel for the petitioner produce the order sheet of the said lease miscase on the next date, which is fixed to imbue commencing from 17th March 2020.
May I also pray that the orders which have led to filing of this miscase in those lease revision cases that have
we are not entering into that. That's it. Pending before the appropriate authority, he is to decide. We are just, the prayer is only to expedite.
Those orders are also not here in the writ, so I can't even see
which order are not.
Jetiକି order ରୁ ଏ lease miscase arise ହେଲା ସେ ଲେଖିଛନ୍ତି. There is no single order here.
No, single order and annexures ଗୁଡା ଦେଇନାହାନ୍ତି. ଆରେ
ROR ଆଉ sketch map ଅଛି ଆଉ miscase ଟା.
You have annexed 4 annexures, so 4 documents as annexures. Why have you not given the copy to the State Council? Yes, sir, annexure ଦେଇଛି ନା. ମନା କରୁଛନ୍ତି ପରା.
No, he is saying the relevant.
He is saying the ADM drop order is necessary.
Entire narration starting from 79 ଯେବେଠୁ lease grant ହେଇଛି, and there are a series of orders which have finally led to the filing.
Mr. Nayak, he could have.
WL case number, everything is there. This is the stage.
WL lease case, your lordship can see. After depositing of salami towards 50% of land cost. We just
the order sheet diyantu darkar hala the next day we might direct if it is necessary.
Order the certified copy appeal file is xerox copy is there. 17th of March 2025.
Next day.
Yes. 17th March. No. Rohira season.
Item 8.
No, please. Item 8, my lords, pursuant to my lords order dated 11/2/25, I pray for some time, my lords, 2 weeks time. Further time.
Why the compensation amount has not been disbursed in favor? Or there is an order of the court also, senior civil judge.
Yes.
And deposit is there since 2011, my lord.
Yes. So directed to the instructions, I pursue and get it, my lords. 2 weeks time.
2 weeks time, all right.
Sometimes dispute arises, who will take? So let him get in.
That has been decided.
We are fixing it on 17th.
My lord.
The land council for the state seeks some further time to obtain instruction in terms of the order dated 11/2/2025. List this matter in the week commencing from 17th of March 2025.
Item 9.
Item 9, may I please, your lordship?
Yeah.
Your lordship, here the matter is related to disbursement of compensation after reference under Land Acquisition Act, your lordship. The petitioner's land was acquired for the construction of Upper Indravati irrigation project, and he was awarded the amount.
There is already a court order.
Yes, your lordship.
So
No appeal.
No appeal, your lordship.
Some writ petition order you have given?
WPC number
Similar order.
225804.
Similar order.
Yes,
We are not following.
Annexure 2.
ऐसे instruction लगा होते जो appeal परिचय नहीं यदि appeal करना थी like the previous order. So ये जो previous order था जो थी चला सही type of कर he has to obtain instruction regarding exactly same type of.
Item number 10 also similar, your lordship.
10 में से ही court order अच्छी.
Court order अच्छी, your lordship. Annexure 1.
ठीक है रोन. Court order अच्छी. अच्छा. सही type of order कर दिया. Layer case number होगा वो. Court सब ना सब समान.
Yes, your lordship.
ये जो previous order था मुझे उठा कहले नहीं का.
17 March.
WPC 17 मार्च को रहला ए जोटा 8 नंबर ऑर्डर नंबर 1 को पड़े आसंतु हां सेही टाइप रो करी कि ओटा कर लेथिबे इंस्ट्रक्शन में
Item number 11 may
just a minute like item number 8 order number 1 एमती लिखथिले जଣା पड़ जियो चेंज करिवे 11 भी से like item number 8 order number 1 ଆଉ ଗୋଟେ କୋଉଟା କହୁଛନ୍ତି
item number 9, 10, your lordship, and 11 may be permitted to withdraw, your lordship.
अच्छा एटा होची 9 10 रे सेही टाइप ऑर्डर हो
Yes, your lordship.
like item number 8 order number 1 11 टा आपण विथड्रॉ करिवे
Yes, your lordship.
दियंतु मेमो दियंतु
Infractious
Liberty to file a fresh application.
fresh read petition
Yes.
Why?
कोन असुविधा
Your lordship, here the petitioner's mother and father, they have the petition father was the initial claimant in the court below, your lordship.
So those details you have not given.
Yes, yes, yes.
all right
Better particular.
the land counsel for the petitioner files a memo for withdrawal of the writ petition to file it afresh with better particulars. Disposed of memo is accepted, disposed of as withdrawn, giving liberty to data memo from
Well, items 9 and 10 from the 17th of March.
1990. Yes.
Okay.
Any other matter similar? What is about 13?
9, 10, 11, your lordship.
नहीं ये आपन 13 नंबर टा कहउथले सी टाइप रो कियो
नहीं, your lordship, more on 9, 10, 11 थिले.
अच्छा नॉट योर ऑलराइट अच्छा अविनाश
Yeah.
what you see it अच्छा ऑलराइट
Item 12.
yes Mr. Sahu
Please, your lordship. Petition is seeking a direction to the appeal number 3 to reconsider the appeal memo filed by the petitioner, which has been dropped as withdrawn.
reconsider the appeal case कौन हला dropped कहीं से order कहीं
Page 14, my lords. By C 22/11/23 order, my lords, page 14.
हां पढ़ो तो order टा
The case record is put up today. The required para-wise report relating to the case land is received, which is attached in the case record. The learned advocate for the appellant is present and filed a petition with a prayer to withdraw this case on the grounds stated therein. And here is the case record. Yes, sir. Back after due service upon the package, it is ascertained that the appellant has no interest to proceed in this case. And on the strength of withdrawal petition. Hence, this appeal case record
Why did you
number
withdraw?
167 about 2023 is dropped as withdrawn by the appellant.
हां कौन हला माने कौन पई विथड्रॉ कले पुणी कौन पई चाहुचंती
Later on, the petitioner came to know that the land which has been allotted to him on the by virtue of the lease deed was not recorded in the current settlement operation. Other allotage, land of the other allotage has already been recorded in the draft.
No, we do not know.
That is why you withdrew.
आपण पारावाइज रिपोर्ट आसीगला आपण ताकू न पढ़ी किनी किसी न करी इंस्ट्रक्शन न नेई आपण केमती फाइल कर दोथले पिटिशन टू विथड्रॉ आ सी विथड्रॉ है कि डिस्पोज ऑफ हेगला तापर पुणी कहउजनी नाही हमर मेरिट रे सुनानी हो
The advocate, concerned advocate has made prayer.
कोन सीधा मनु मन कर देले proceed against him in the if without taking instruction from the client he has withdrawn the appeal proceed against that advocate.
Unless you explain why it was withdrawn, we cannot do that because dinne withdraw, dinne yes, and they that is why we are asking you give a memo why you want to withdraw. Also, we are
Where is that
asking.
withdrawal memo? You have stated the grounds in the withdrawal memo. Why are you withdrawing it?
So memo is not.
Aren't you? Lekhi Jandija, the learning counsel for the appellant filed a petition with a prayer to withdraw the case on the ground stated therein. कोनो reason देइथिबे एथि पई मु withdraw करिया चाहूची.
I have applied for the certificate copy of the.
apply कर दियो.
I am not.
When?
केबे रखियो चाहूँ
The pleadings also need to be amended because prayer portion says that the appeal case number 167 of 23 was dropped to non-prosecution.
No, that is not correct.
Was dropped due to non-prosecution, giving sufficient opportunity of hearing. That's comma full stop so meaning not giving sufficient.
Was dropped due to non-prosecution कोडी हुए आपण जदी non appears ହେଲା ताले सी हबो एठी पर आपण निजे पिटिशन फाइल कले विथड्रॉल हवा को से ऑर्डर ता पास होला एमथि केमथि लिखतिले प्रेयर पोर्शन ने which was dropped due to non-prosecution.
Subsequent question is argued by that one.
Literal memo ta anantu seta dekhiki.
If bring that withdrawal memo with us. And thereafter, if necessary, this prayer portion is to be amended.
With the pleading views.
Pleading भी भीतर of the agent.
ବୁଝିପାରିଲେ ତ unless you explain କଣ ପାଇଁ withdraw କଲେ ଆଉ କଣ ପାଇଁ ଏବେ ଚାହୁଁଛନ୍ତି
Grant some time to obtain that.
English ରେ ହଉ ଠିକ ଅଛି.
All right, this writ petition has been filed by the petitioner Srinath Bhanja with a prayer for recalling the order dated 22/11/2023. And for hearing of what is the appeal case number?
167
Appeal case number 167 of 2023. Disposed of by the settlement officer to hear it on merit afresh. On perusal of the impugned order, it reveals that the learned advocate for the appellant filed a petition with a prayer to withdraw the case on the ground stated in the petition. The learned counsel for the petitioner submitted that without the instruction of the petitioner, such a petition was filed by the learned counsel for the petitioner before the settlement official. Stop. Let the copy of the withdrawal memo, certified copy of the withdrawal memo, be produced on the next date, which is fixed to upon.
The certificate copy is very time taking in the settlement office.
You want 3 weeks, 4 weeks? Kete saptah?
4 weeks.
You know, the Samanu. This matter 24th March 2025.
Mr. Sahoo?
You are, what is your good name?
Mr.
Kailash Chandra. Yes.
Item 13.
Item 13, let's see. On behalf of Mr. Ratho, kindly pass over.
Sorry, Your Lord. Beg your pardon.
Yes. 13.
The sole grievance of the petitioner, he has filed a Bebondavasta revision before the member board of revenue. They have not accepted this and not registering the number also. The petitioner's case is that the land is in his name. In a Somata revision case, Tahsildar has recorded it in the name of the Tahsil.
On the register Kunna.
Annex 3 ta. Annex 3 is the Bebondavasta revision case I have filed under section 38B of OE Act vis-a-vis the GO given by the government in
Challenging which order? Because 38B will be against some order.
Your Lordship, that order, Your Lordship, kindly have a glance too.
Yes. You have given 2 circulars, no orders.
Page 55 is the.
Am I looking at the wrong matter or?
No. That is the annexure number, annexure 3.
Annex
Page
3, Your
25.
Lordship.
Yes.
20.
Copy of the petition. Where is the
Yes, sir.
you are challenging?
Page 25 to 36 is the petition, Your Lordship.
Please come to the please come to page number 28.
Yes,
the
sir.
prayer portion.
Yes, sir.
The question that has been put to you, that in the prayer portion, in this which order you are challenging, because you are mentioning geo number so and so,
Yes, sir.
EM dated so and so. So any order you are challenging?
No, the record has been corrected in the name of the state, Your Lordship. It is earlier recorded in the name of the petitioner.
Mr. Bhuya,
Yes, Your
the
Lordship.
record must have been corrected pursuant to an order. This 38B says any decision by a subordinate authority. So unless you tell us what is the decision, how can we ask them to register or dispose of your revision?
Your Lordship, kindly have a glance to the geo I have given in Annex 2, Your Lordship.
Again, geo? As per the geo, it has been corrected.
Your Lordship, for a moment, 21, page 21, kindly have a glance.
Yes.
The member board of revenue,
Yes.
para 12, Your Lordship, 21. The member board of revenue, Odisha shall have the power to review, revise any case instituted, rejected or dismissed, allowed or pending with any authority subordinate to him or his own motion on an application made by the collector of any district at any time, subject to overall provision of OEA and rule and guidelines. I am taking the cue from this, Your Lordship. Reason being, the ROR right now, ROR stand recorded in the name of the state, Your Lordship. My Stitivan land has been recorded in the name of the state.
Any case instituted, rejected, dismissed, allowed, pending with any authority also.
Yes, Your Lordship. For that reason, I am saying that if I don't have a case, let him dismiss my revision also.
If it will not come then. So like no other remedy, only he has 38B or something else is also there.
Why they have not registered? I have to.
No, not why.
No.
Any other remedy? I'm asking you any other remedy there.
That this was filed in 25.
Yes, sir.
So the day, which date you have filed?
That is your last 2023, 2025.
3125.
Yes, sir.
It may be so that in some authority, unless you remove all the defects, they may not register it. Like in our case, it is in High Court also, it mentioned it is defect law. If they defect remove
they are not accepting it.
Accepting
that is my case, you know. Annex 3 ଟା ତେଣୁ ମୁଁ ଦେଇଛି ତା ଫର୍ମାଟ ରେ ବି ମୁଁ ଦେଲି ଯୋଉଟା ଦରକାର ଅଛି ଯାହା ଯାହା ଡକ୍ୟୁମେଣ୍ଟସ Annex 3 ର page 25 ଟା ସେଟା ଦେଲି but they are not
ଗଭର୍ନମେଣ୍ଟ କଣ ନେଇଛନ୍ତି ଆପଣ ଫେରେଇ ଦେଲେ ବୋଲି କଣ You have not stated that they have returned your. You have stated
paragraph 12 years.
Come to paragraph 10.
Yes, your lordship. That the petitioner, after obtaining certified copy of the order of summatory case, has prepared OA revision in view of the circular of the government of the year 2017 to filed before the opposite party. When the petitioner presented the OA Bandobast revision for registration of the case, but the official opposition has denied to register the case, that opposition has given instruction to his official not to register any case so far as the case is concerned. A true copy of that.
Paragraph 4, you stated the Tahsildar has disposed of the proceeding instituted against you by directing it to be recorded. So that order, unless you challenge in the appeal, how can it be? So where is your appeal? What have you challenged? Paragraph 3 background.
You have been repeating them.
Sorry, 4. Sorry, 5.
5 year old.
5 to 3 so it is 5. Yes.
It is in the year 2000, your lordship. After that, 2017 GEO has been come into force. I do admit, your lordship, I have to challenge that. But the fact remains, right now the property is Abadjogya Onabadi and the land of the present private land of the petitioner has recorded in the state. until unless
you have not stated that they returned your petition. You have stated that you presented they did not register. There is two different meaning to that. ସେମାନେ ରଖିଦେଲେ ରେଜିଷ୍ଟର କଲେନି ଇଏ ଗୋଟେ କଥା ଆପଣ ବର୍ତ୍ତମାନ ସବମିଶନ କରୁଛନ୍ତି ଆପଣଙ୍କୁ ଟୋଟାଲ ଫେରେଇ ଦେଲେ ଆପଣଙ୍କ ପିଟିସନ
ଅରିଜିନାଲଟା ରେକର୍ଡ ଦ୍ୟାଟ ଇଜ ଫେରେଇ ଦେଲେ ମାନେ
ନାଇଁ ନାଇଁ ପ୍ରକୃତରେ କଣ ହେଇଛି
ଫେରେଇ ଦେଇଛନ୍ତି
କୋଉଠି ଲେଖିଛନ୍ତି
para 11 that your lords that it has been specifically ordered right to review revise the matter subject to all provision of the OA Act rule and guidelines issued from time to time to deal with matter of not registering the case is unsustainable in the eye of law. For that reason, your lordship, annexure 3 is the format which has been
not registering the case is unsustainable. Empowered to deal with the matter, but OP number 2 is not registering the case is unsustainable and liable to be directed to.
Are you not seeing that any difference between not registering after presentation and returning the case totally or the petition to you? Is there no difference between
yes,
the two?
That is
not registering means they have retained your application.
They have retained and but not giving the number.
Yes.
So that is why your prayer seems to be like that.
That amendment is not that they have written because the original file I have given.
Then how can we say if you have taken back? Let us say you have taken, they have returned to you and you have taken back. How can we pass direction to register the case? Unless the documents are available with them,
yes.
They have kept it with them. How can we say? They will say that it is not before us. How can we register?
They are not receiving the counsel.
Counsel, your prayer is, your government is something different.
I do admit there is.
You are making a submission which is not there in the writ petition.
Lordship, my respectful submission is that I have given to the.
No, your pleading is not that.
I will file an affidavit to that effect that they have returned it.
No, if you want, we can proceed that they are not. I
will file your lordship. I will file it. Let them at least.
No. You file first of all. File. Let us know the correct state of affairs. We cannot.
And paragraph 5, you yes, refer to the order, but you have not given the order.
File it. This petition has been filed by petitioner Nusingha Narayan Bhansdev for a direction to the opposite party number 2, member Board of Revenue, Odisha Qatar, to register the case under section 38B of the OEA Act, inter alia with other relief. In the writ petition, grounds have been taken, particularly in paragraph number 10 and 11. Averments have been taken in paragraph number 10 and 11 that when the petitioner presented the OEA Bandobast revision before the opposite party number 2 for registration of the case, the officials of the opposite party number 2 denied to register the case.
Submit everything, they have returned it. Yeah.
In paragraph 11, it has been stated that the opposite party number 2 is not registering the case. However, Mr. Jagannath Bhuya, Land Counsel appearing for the petitioner, submitted that the Bay Bandobast revision petition was returned to the petitioner by the member Board of Revenue, Odisha Qatar, when it was presented on present
3/1, 2025. 3/1, 2025.
Before in the office of the Board of Revenue, Odisha Qatar, On 3/1/2025.
2/1/2025. Second January 2025.
Affidavit.
Second January.
Affidavit ହେଇଥିବ ଯେ ଯୋଉଦିନ ଦେଇଥିବେ may not be the same day.
3/1/2025. The submission of the land counsel for the petitioner is contrary to the averments taken in the writ petition. The land counsel for the petitioner seeks some time to file an affidavit in the light of his submission made today and seeks for an adjournment. केवे रखियो फोन पे?
Lordship on 5.
Next week.
Next week.
Acha. Place this matter on 5th of March 2025.
And the order in past in OEA case,
Put.
the jo OEA case jota mane kono goda challenge kari that order
The out paragraph लिख दूँ तो सब output लिख दूँ. The land counsel for this one submits that the Bay Bondobosto revision case was sought to be filed challenging the order passed by the Tahsildar Rarua in Somoto case number 6 of 21.
2001. OEA 6 of 2001.
Somoto OEA case number 6 of 2001. The copy of the said order be also annexed to the affidavit. Yes.
Little more time, Your Lordship. Can it be on 12th, Your Lordship?
Put up से जो 5 तारीख रखी थी काटी दियंतु 17 तारीख रखी दियंतु 17th March 2025. We are just coming.
Item 13.
May I please, Lord? My Lord, I may be permitted to withdraw this case. I may be permitted to withdraw.
What is your good name, Lord?
S.K. Das. Asit Kumar Das.
Asit Kumar Das, Land Counsel, appearing virtual mode. अच्छा सेटा लिखी दो
My Lord, not filed in proper format.
परमिशन
Not filing proper format, liberty non nella file भी कर परिवेनी.
Then to file better application.
सेटा कहना कि मैं you are to file an memo also. No.
Yes, my Lord, I file.
ଆପଣ କି associate ନାହାନ୍ତି?
ଅଛନ୍ତି my Lord, I will send my Lord.
କୁହନ୍ତୁ memo ଆଣି ଗୋଟେ ଦେଇଦେବେ ସେ ଅନୁଯାୟୀ.
Yes, my Lord.
ଦସ୍ତଖତ ଥିବ
associate କର ଯାହାର ଦସ୍ତଖତ ଥିବ ତାକୁ memo ଆଣିକି ବର୍ତ୍ତମାନ ଦିଅନ୍ତୁ.
ଯେ memo ଦେବେ ତଳେ ନାଟା ବ୍ଲକ ଲେଟର ରେ ଲେଖିଥିବେ.
MK ପାଣି ଅଛନ୍ତି ଯଦି ତାଙ୍କୁ କୁହନ୍ତୁ ଆଣି ଦେଇଦେବେ ମ୍ୟାମ୍.
Yes, my Lord, yes, my Lord.
Memo କରି ଉପରେ ଲେଖିଦେବେ each may read petition of file memo is taken on record disposed of as giving liberty to the file press read petition.
Item 15.
May I please, Lords?
Before your lordships kindly clear the petition. In this case, I have been included as opinion number 4, and that I was instructed to appear. I can assist your lordships after the petitioner submitted.
My Lord, may I take my Lord to the annexure 1 at page number 11?
What is your prayer?
But I have an innocuous prayer to consider my representation within a stipulated time period.
Which is your representation?
Let's say matter related to land acquisition. I have never paid any compensation and was not.
Which is your representation?
Annexure 4.
Annexure 4. When you have given that representation?
It was received on 6/1/2025.
How will you know that? What he received is?
She received question.
So, why have you come so soon to the High Court?
Because there is urgency. What happened in this matter?
No, you might have urgency, but are you expecting that the district magistrate collector has no other work than to dispose of your representation within a month?
This is a matter related to my life.
तार आउ किछि काम नै डिस्ट्रिक्ट जज कर मैं जो डिस्ट्रिक्ट मैजिस्ट्रेट कर ताको पाखरे दिनकु 100 1000 पडुथिबो रिप्रेजेंटेशन ता छडा तार अन्य ऑफिशियल काम थिबो तो आपन को रिप्रेजेंटेशन गोटा फाइल कर देले जनवरी मास 6 तारिख रे ताकू फाइल डिस्पोज ऑफ कलेनी बेली पळे आसले फेब्रुआरी रिट पिटिशन फाइल कर देले.
Well, the matter related to land acquisition and apprehending that I will be disposed.
Inordinate delay hela आपण हां गोटे आसीबे तो एठी माने तापरे कहबे जे हाई कोर्ट रो ऑर्डर नेकिन आछी आपण डिस्पोज ऑफ करन. Why will pass this order?
1 month considering the nature of the grievance, any time, because the company has in the legal notice they have informed that
merit re kon apon representation karibe no karibe apon kon ye achi, that's a different matter, but the question is that you are making a specific prayer that the representation should be disposed of, but we find it was just 1 month back you have filed the representation. Why will pass the direction?
Another thing, in your representation, you have stated that in 1996 you have got a rehabilitation identity card. So suddenly after 30 years you will come and say that
what after that card I was never paid any compensation.
That is all right. So what
and the land has never been acquired because I am possessing the land till date.
Suddenly rehabilitation thing is given only after land is acquired, not before it is acquired.
It was never acquired, Milord. I was till that date I am possessing that land.
What is the meaning of acquired?
Acquired means if it goes to the that becomes encumbrance free, then it becomes acquired.
So if it has been acquired and you go back and occupy the land again, does that mean it has not been acquired?
Milord, it is. It was given in that I have never paid any compensation. Anything was not given.
That you will be paid. We are only saying that why suddenly you will give it before 1 month and say we dispose of 1 month.
Because suddenly we came to know.
You see, there may be necessity also for hearing the other side or for calling for some document to dispose of the representation. Why you pass that 1 month, within 1 month your representation would be disposed of, and what is so special in your case?
That
When so many applications might be, representation might be pending before the authority.
my lord, if my lord's permits, I will satisfy my lord that there is sufficient apprehension.
No, this is not. Your prayer is we are not entering into the merits of the case. Certainly will not. Look, this petition has been filed
My lord,
for a direction to the opposite party number 2, Collector, Jajpur, for consideration of the representation under Annexure 4 in a time-bound manner as per the provision of law. Mr. Satyasmruti Mahanti and his associates have filed Bhinama, and Mr. Suryakant Padil and Senior Advocate has also filed the appearance memo for opposite party number 4, which are taken on record. The representation has been filed, has been received in the PR section of the Collectorate Jajpur on 6/1/2025. There is no such inordinate delay till now for passing an order to the opposite party number 2 to give a direction to dispose of such representation in a town-bound manner. Accordingly, we are not inclined to entertain this petition, which is accordingly dismissed. Yes.
Yeah, Mr. Pati.
Madam.
And Mr. Soumya Ranjan Pati.
Item 16.
That item 16, 17, and 18, if they short adjournment, my lord, I will obtain instruction in you.
The contempt गुड़ाको कौन ପାଇଁ file ହେଇଛି ଲେଖିଦେବେ ଏଇଥିପାଇଁ file ହେଇଛି the land council for the state 6 weeks time.
Short means what? 3 days.
My lord, next week.
Take enough time and don't keep asking for adjournment.
17 तारीख 17 March 2025 है ना for obtaining instruction. Yes. 3 टाइप मैटर. So 16, 17, 18.
Yeah, Mr. Samantray.
And Mr. Bhaskar Samantray. And counsel. Yes.
Item 19.
May I please say, my lord, in this case, I have filed a IA, that is 3303 of 2025 for amendment. That IA is not 3303.
Affidavit has not, that amendment has not come on records.
3303 of 2025 for amendment. And you have given a copy to the state council. It is available with you?
No, matter.
It has been. All right. You are Mr. Naik. Mr. S.K. Naik, Land Council, appearing for the petitioner, submits. When you filed this interim application?
My lord, 21/2/2025.
That on 21/2/2025, he has filed an interim application with IA number P303 of 2025 for amendment. And copy has also been served.
No, copy not served.
The receipt copy of the same has been served on the Land Council for the state.
Mr. Naik.
Receipt though. Let a copy of the interim application be served on the Land Council for the state. Matter will be listed next week, along with IA number 3303 of 2025.
Item 20.
Order says, no, consider why. Please lost. Writ application, writ appeal has been filed, challenging the Honorable Single Judge order dated 29/2019, passed in WPC number 170/2010, wherein the single judge. No, just a minute. The last order is passed on 21/1/2025. That has been complied, and I have. And you have entered appearance by filing the appearance memo on that day, and you made a submission that as per the order dated 21/11/2024, you have filed the calculation sheet and supplied the same to Mr. J.K. Ratlan, Senior Advocate, appearing for the respondent. Mr. Roth on that day submitted that he has received the calculation sheet and he is required to obtain instruction from the respondent on the calculation sheet. So, Mr. Ratho, you have already obtained instruction.
Yes, ma'am.
Okay. So, this calculation sheet, according to you, reflects the correct state of affair, or you?
Correct, sir, ma'am.
Yes. So, what do you say? Madam, pursuant to this calculation sheet has been filed, pursuant to the order dated 12/4/2023 of the coordinate bench, my lord. While hearing the matter, on court has been expressed. 12/4/23. Yes, my lord.
12/4/2023.
Please come to that order. My lord, respondent had completed 55 years. May I placing, my lord, that? Yes, yes, please. In 2010 itself. Therefore, even if the impugned order of the client single judge were to be implemented, he would have been superannuated in 2015 itself from attaining age of 60 years. Consequently, all this is to examine at this stage the constitutional benefits that respondent would be entitled to if the impugned order of the single judge were to be implemented. Both the party are directed to file respective calculation of the benefit that the respondent would be entitled before the next date. The Central Government Council for the appellant will also indicate what amount has already been paid to the respondent. So, in terms of that order, then the next matter came, the next date it came to 21/11/2024. My lord. Please place that order. So, 21/1/2023. Right. Yes. The Mr. Mahana, Central Government Council appearing for the Union of India, filed his appearance memo, which is taken on record. He submitted. Which order you are placing? 21/1/2025.
21/11.
21/11.
Order number 12.
I'm pressing. In terms of the order dated 12/4/2023, Mr. Vijayant Kumar Ratho, Senior Advocate, has filed the statement of financial benefit that the opposite party, Ramchandra Mahapatra, is entitled to get the period from 1/11/2010 to 31/10/2015 and the gratuity approximately with the affidavit of the respondent. Copies of the affidavit along with the statement of the financial benefit has been handed over to the appellant, who submitted that in terms of the said order, he has to prepare a calculation sheet and he has to file within 10 days, giving copy thereof to the Learned Council of the respondent. After upon calculation sheet prepare kole, तांकु hand over kole, सी वर्तमान पहुंचंदी ठीक अछि. तो कौन असुविधा हला पैसा दवा? Well, so far as the merit has not been taken up, the court has not taken up so far merit of the case concerned. Merit of कौन अपन तो राजी हेले calculation sheet करियो देबा को calculation तेले. If it would not be allowed, on the honorable court's observation in that respect, but he is entitled if the writ application, writ appeal, writ order of the honorable civil has been implemented. कौन टा अच्छी सेमती single judge order रे जोटा को interfere हो.
Exactly that is the I am assuming the order that the premature retirement the petitioner.
Which order you are challenging in this writ appeal? Order dated 29/2019.
Yes, madam.
Yes.
Under annexure 4. I believe part of that. That is annexure 3 at page 36, madam.
कितने amount होची Mr. Ratho? Calculation कला पर.
That will come around, my lords, the total amount will be taking up to 2015, it will come out to 22 or 23 lakhs like that.
Maybe it is not here agreed. I will not tell you that very so you have to check the derivative about it. Okay.
The debit at page running page 2 indicates the amount to be paid.
The application may not the assent of the petitioner before the honorable single judge is
no, Mr. We are under an impression that when the order was passed on 12/4/2023, you perhaps did not challenge, stick to that, challenging that. ଯେମିତି କିଛି ଲେଖା ହେଇନି ସେଥିପାଇଁ ଆପଣଙ୍କୁ କହିଲେ ଯେ ଏମିତି 55 ବର୍ଷ ହେଇଗଲାଣି ତାପରେ ସେତିକି ରିଟାୟାର କରିଥାନ୍ତେ ତେଣୁ
that order itself is reflected. You also may kindly see.
Yes, you come to the impugned order. Let us see.
You also may kindly see at annexure 3 page 36. The fact of the case is that the petitioner was granted premature retirement in the Sonic Society regulation. That regulation of 5.30 after completing the retirement age of that is 55 years. Yes, sir. That has been assent in this writ application. While considering the case of the petitioner, has been set aside the order passed by the appropriate authority.
No, what was the allegation against him? Why he was
that the compulsory retirement that you will also may kindly see that I honorable single judge quoted that provision under which the petitioner has been retired. You will also may kindly see at page 43, internal page 7. The last one, the rule 5.30 of the Sonic School Society rules and regulation 1997. Page 47, internal page of
page
the judgment.
47.
43. Sorry, 43, internal page of the judgment, page 7. The retirement age of the academic staff would be 60 years. And that
43 खोल retirement age टा कोठी
that's
हाँ जो quoted ये हाँ all right
vision of
yes got it
please continue.
The retirement age of the academic staff would be 60 years and that of the administrative staff and the general employees 55 years. However, the administrative staff and the general employee can continue to be serviced up to 55 years subject to the following conditions. 1. The principal satisfies himself every year regarding the efficient performance of the services by the staff and the medical fitness and certificate by the school medical officer.
Our case
that the principal has been issued that under annexure 4 of the writ application for the premature retirement.
But on what ground?
On what ground?
That has been explained in my counter affidavit.
Or
that yes, ma'am. That has been
but not discussed in the impugned judgment.
Yes, madam. Discussed.
Where?
I'm just placing subsequent while that I will
okay.
that this provision of order rule 5.30 subsequently amended. That will also be put in the next page. So that 55 years is extended to 60 years. And then on, you'll also may kindly see, para 8 is the impugned order which has been quoted by the learned single judge. You'll also may kindly see the memorandum dated 29/9/2010. You'll also make a page 8 of that internal judge order. The office memorandum extension of service beyond the age of 55 years. Reference rule 5.30 of Sanitosku Society rules and regulation 1999. You will be completed 55 years of age on 26 October 2010 in accordance with the relevant provision of the Sanitosku Society rules and regulation 1997. And in exercise of the power conferred by the relevant rules, it has been decided by the competent authority not to extend your service as a hostel superintendent in the school beyond the age of 55 years with effect from 27 October 2010. You are hereby advised to submit all the required papers to establishment section to process the admissible determined benefit and also complete the clearance formality at the earliest. You will be retired from the service in the afternoon of 31st October 2010. This provision in the Sanitosku rules and regulation is parametric to that Orissa Service Code 71(1)A, the premature retirement to the officers, those who are incompetent to continue in the service. And that exercise has been invoked by the principal, and this order has been passed. What happened in the prior to, you'll also may kindly see that an annexure, I have also enclosed, you'll also may kindly see, read petition, entire read petition have been enclosed. Page 28, you'll also may kindly see, running page 28. Just prior to that issuance of notice, this order has been passed by the principal to clarify regarding detention and arrest by the respondent before the police, Saidnagar police station. You'll also may that at
the petitioner was arrested.
Yes, ma'am. He is taken to custody.
Petitioner, sorry. In this case, it is respondent. Respondent was arrested in connection with a criminal case.
Yes, ma'am.
Under 420 IPC.
Yes, ma'am.
Yes.
And subsequently, he has asked to give explanation to the principal.
He was released when he was arrested, when he was released?
On the very day that
the very day. Acha. 13th September 2010.
Yes, ma'am. That you'll also may I am placing that the explanation short from the principal to the petitioner and respondent. You'll also may kindly see at page 28.
28.
Page 28, running page 28. It's the part of read petition.
28. So.
हाथ लिखाटे अच्छी ना 28 ना 29
नहीं 29 हो
28 होची show cause
28 show cause you are directed to submit the full details and circumstances of the case and on or after your arrest on detention. You said that is 28 अपना page number भूल लीजिए
28 annexed to
that is the show cause.
Yes. That I want.
They're asking for information rather. He said you did not inform about this. So.
Yes, ma'am. That the nature of the work, my lord, can be visualized, madam. The petitioner is the superintendent. The respondent is the superintendent in the boys' hostel of Sanitosku School Society. The Sanitosku Society is the very disciplined society. The cadre, the person, the kids, those who are continuing the study, for the preparation of to join in the defense service and all other artillery, that Air Force and Naval, they should be given a discipline and a proper honest life to pursue their career. So far as this petition is the conduct of the petition that he is arrested and he filed an compromise petition. The allegation is that affair is that matter. He obtained 15 lakhs rupees to give the informed son admission in the MBBS course manner. And subsequently, he filed a compromise petition with the police. And pursuant to that compromise, he submitted to give 8 lakhs to the complainant and due to such compromise, the honorable magistrate has been released on bail to the petitioner.
No, rather the reply which has been given by the respondent,
My lord.
he has mentioned in page number 30
Yes, ma'am.
that why he could not able to intimate you, that's one thing.
Yes, ma'am.
But he has stated that as per the direction of this court or something, I moved the bail application before the honorable court.
Yes, ma'am.
And thereafter released from police custody by submitting the bail bond. Maybe it is an anticipatory bail or something like that.
No, my lord, regular. Before
Regular
the
bail.
magistrate. This also communicated by the IIC Sajnagar police station to the principal.
So he was arrested and or he himself produced that bail order, and in terms of the anticipatory bail order, he was in the event of arrest jota hue. Eta kon actually kon hai?
That his regular bail has been granted by the magistrate.
So police station informed me to meet him. So accordingly, I met him in the police station, and there I came to know that the FIR was lodged by one so on the offense under section 420. The officer in charge, without hearing me anything from me, made arrangement to produce me before Swans. I moved a bail application before the honorable court, and thereafter released from the police custody. Swanso. से 41 compliance न करी ताकू डाकिले नोटिस पठेई थांदे आपण जी भी हो 7 वर्ष आपनकर पनिशमेंट थिबो ताकू थाना को डाकी आनी ताकू कोन कोर्ट फॉरवर्ड कर दो बसले
that subsequent document that she released.
तापरे बेल हे गला तापरे कोन अपराध तापरे कोन हला
that after that मतलब this memorandum of issue for his compulsory retirement taken in account the entire service career of the petitioner.
आपण बड़ा कोजिन ए जो इंटीमेशन से देई नथिला बेली ताकू जो पुलिस को जो
I maybe explain the lordship, my lord. The provision of a compulsory retirement, while considering the entire career of the petitioner, the appropriate authority take to the decision, and for the continuance of the petitioner and respondent in the Saniko School Society to continue as a superintendent of the boys' hospital hostel is detrimental to the interest of the organization. That's why this letter.
How and why detrimental?
आपण जोड़ा कहउछंती
service career there is number of warnings.
So say that
I'm just what is that occasion what prompts.
So say what are the allegations against him, then we consider whether this is
disciplinary proceeding initiative थिबो ता अगेंस्ट एवं फाइंडिंग आस्थिबो ता अगेंस्ट ए सब जिंस आपण हठात ए जो कारणटा कहउछंती
I'm just that this action has been taken by the principal, taking in account the entire service career record of the petitioner. You also kindly see in the counter affidavit part we have mentioned at para 6 at the joining page of page 33. You also may kindly see. I have also that annexed the counter affidavit.
आपनकर रीट अपील ले काउंटर एफिडेविट अनेक्स करचंदी
Again, that read petition copy annexure 1 and annexure 2 is the counter.
रीट अपील का
Read appeal le achi. That part of the record.
annexure 1 ला काउंटर होची आपनकर annexure 2 हां कोन लिखि
page 33 lords me
33 हां
para 6 that the averment of para 4 is incorrect and denied by the opposite party. The records of the petitioner maintained in the Saniko School, Bhubaneswar, reveals that during his tenure as a hostel superintendent, he was served with advisory notes, counseling notes, warning, etc. for indiscipline and activities, declaration of duty, doubtful integrity, lack of sincerity, devotion towards the duty, etc. In this context, it would be worth mention here that the chairman, local board of administration, Saniko School, Bhubaneswar, who is the authority for general administration supervision of the school, he had made the following observation about the petitioner on his general activities during May 2001. Having perused the representation of Sri R.C. Mahapatra, respondent, the hostel superintendent parawise comment by the principal, Sainiko School, Bhubaneswar, and recommendation of the commander B and O sub area, I am of the opinion that adequate opportunity has been afforded to Sri R.C. Mahapatra to improve his performance by frequent counseling by the principal, Sainiko School, Bhubaneswar. It is evident that in spite of such repeated counseling and warning issued by the principal R.C. Mahapatra, he had not improved his performance and conduct. To constitute the counseling and warning letter issued by the principal as a harassment and a torture, and alleged by the petition is completely distract of the actual event. This is the observation I passed in his service book earlier in 2001 itself, my lord. And then, so far as all the warning and the censure which has been done, moved against the petitioner, I have also filed. You will also may kindly see flag E and then flag C. You will also may kindly see flag C. I have given that detail of proceedings and the warning has been
flag E.
Flag C, my lord.
Who to flag C?
Flag C, my lord, that flag C, you also may kindly see. Subsequently filed, copy
এটা ଗୋଟେ IR ফাইল କରିଛନ୍ତି ନା ନାଇଁ ଗୋଟେ ଅନ୍ୟ ଗୋଟେ ଦେଇଛନ୍ତି
ଆଜ୍ଞା
ଆରେ କପିଟେ ଦେଲେନି ତାଙ୍କୁ
ଦିଆହେଇଛି କପି ସାର୍
ଦେଇନାହାନ୍ତି ଏବଂ that has been dealt with by the honorable single judge. Everything has been dealt with.
କହିଲେ କପି ଦିଏନା ଆମେ ଜଷ୍ଟ ଖାଲି
ଆଜ୍ଞା ମତେ କପି ସେଇଟା ଦେଇନାହାନ୍ତି
ହଁ ଏଇ ଏଗୁଡାକ
the details that entire career his the warning and the censure and as well as the disorder proceeding which has been initiated in the petitioner that has mentioned here. You will also kindly see
କୋଉଡାକ ତାଙ୍କ ଏଗେନଷ୍ଟ କହିଲେ ଏଇ ଯୋଉଟା ଫାଇଲ କରୁଛନ୍ତି
my lord, you will also kindly see
କନଫିଡେନ୍ସିଆଲ ରିପୋର୍ଟ ରେ
ଆଜ୍ଞା
ଏସିଆର ର କୋଉଡାକ ତାଙ୍କ ଏଗେନଷ୍ଟ ଅଛି ବାକି ତ ଭଲ ଲେଖା ହେଇଛି ହି ଇଜ ଏ ଗୁଡ ଭଲି ପ୍ଲେୟାର
annexure 9 you will also kindly see page 9 of that
page 9
yes,
page 9 to पढ़े
and discipline
हाँ
April 1994 an instant has come to my notice that you have collecting some money from the treasurer in the Yamuna house on the pretext of the depositing it in the bank. It is reported that you have refunded money to some of the students subsequently and some amount is still held back by you. You are required to submit full facts in the above matter so as to ascertain the authenticity of the above instance. Your explanation should reach the undersigned latest by siege work on 26 April 2019. The next maladition. You are semi confidential. Page 11. So cause notice on charge of indiscipline. So cause charge reference explanation submitted by you by letter dated Neil dated to 2nd August 94. The following charges are framed against you in violation of the rules and regulations laid down for Sainiko School staff and the Sainiko School society rules and regulations. Charge 1. In violation of Rule 9.01G of the above rules, you are discourteous.
এটা 1994
Yes, my
94 कौन हला ये जो चार्जेस बड़ा फ्रेम कले कौन हला ultimately
order subsequent page the order has been passed. You will see next page 12.
yes
Order on the indiscipline case number SSB stock 1002 of PC Swanso Mallet Sainiko Bhubaneswar. Sri R.C. Mahapatra hostel superintendent personnel number 1212 of Sainiko School Bhubaneswar was served with a so-called notice on 17 August 94 for violation of Sainiko School Society Rule 9.1G. Discourteous and distemperate and impolite to file Lieutenant R.R. Singh.
Register paragraph 4 को पढ़े असंतु on careful consideration of the materials on record and the merits of the so and so. I do not find any compelling reasons to drop charge number 1 and 3. एदिरा charge रहिरा तापर कौन हला?
That warning has been issued. Now, therefore, under the discretion of power vested in me by Sangyoshu Society, Chapter 10, Rule 10.11, 10.01, you have been severely repeated and expected to positive improvement on your performance and behavior, following which a suitable and serious action will be taken against you as per the rules. But this in my all in endeavor before your lordship's manager, this all has been charges and the proceeding. The entire career has been stained with all these proceedings of the petitioner respondent. That is the reason when considering your lordship, subsequently your lordship may kindly see objection regarding ragging and discipline staff at page 16. And the show cause has been given at page 19, your lordship may kindly see. Yeah, another show cause in 1999. It has been analyzed by the headmaster of the Uttarpur house that you have not performed your duty properly as hostel superintendent of that house. The specific allegations are the under. You have been visited to people of the house only twice during the PT times and once the things on 3rd July 1999 during the game that time, and since you have been taken as hostel superintendent of a big hospital. You have been failed to check the cadre during PT and games time regularly. You have been never attend the house table in the mess during the meals. The bills of the sports item pertaining to Vipatra house were handed over to you on 5th on a show. You are making entire in the ledger. You neither made entry nor taken any other action till 5th August 94. You have been failed to come to the house to check the turnout of the boys before the proceeding for breakfast. You have not come for the night roll call and checking the double cloth. Your behavior with the cadre are unpleasant and unbecoming. You submitted report against the intimate of the house with malafide intentions. Subsequently, my lord, next page also so cause has been issued on 9 August 99 and the different allegations. Your lordship may kindly sir, page 21, that warning has been issued as per his reply. Reference your reply to so-called letter 11 August 99. After a careful study of the reply, it will be observed that your conduct is not satisfactory, due to which the school administration may put to unnecessary embarrassment in the respect of a cadre. Biju Das, as you have failed to substantiate your report. Further, the language that has been used by you in your report is guilty under undesirable, by which the problem further deteriorated without any reason. You hereby warn for the above mentioned lapses and advise to show positive improvement, else action will be taken initiated against you. School next page, man. School written duty, and I the relevant clause I am referring. You lordship again page 26. 25 also warning has been issued on 2nd May 2000. Page 25. Warning. Next page 26. Counseling for performance. The principal found the following in the hostel on the 10th July 2000. That has been given. You in the last para you are expected to mix with the cadre and guide them during normal hour 5:30 a.m. to 10:30 p.m. It is your duty to ensure that all cadre switch off light at 10:30 p.m. and sleep in the time, so that they get fresh and their performance during the day is better. You should be involvement in your next page, madam. All this has been warning has been issued, and Your Lordship may kindly see. While taking in all the warning and the proceeding initiated in the petition and against the petition of respondent, the appropriate authority picked and passed the order of premature retirement. As your lordships know, the premature retirement is not a punishment, only to weep out the dead wood from the organization. And your lordship may kindly see it is a very disciplined organization. But we are producing and creating students for the
Defense.
future
Defense.
The strict discipline and the strict conduct of the person who is holding the post of superintendent is much more necessity for the interest and of the Sanic schoolman. And that is the reason that that order of the passed by the authority. Your lordship may kindly see page 39 is that is the local that has order been quoted by the honorable single judge. This is the at page 39. That is the local board chairman's observation to the representation of the petitioner. Page 39. That has been quoted by the honorable single judge. I have perused the representation of so and so, but that I have already reviewed before. And several, and you know, so please come, you know, kindly come to page 50, award of minor penalty. Page 50. 13th October 2004. May I place it, man, that? Award of minor penalty. Reference to this official letter, SSB 1002, PC 1212 dated 1st September 2004 and 26 September 2004, and your correspondence dated 13th September 2004 and 28 September 2004. The content of your above cited correspondence was studied in detail and not considered. You have hereby award minor penalty of censure for your misbehavior with Sri K.C. Hata, housemaster of the Bigpathar High School house. Next, page 51 is the advisor note against petitioner. And you will also may kindly see, turn to page 67. This is the letter issued by the IIC Sahidnagar police station to the principal regarding arrest of the petition respondent. 67. Principal Sanic School, Bhubaneswar, Sahidnagar PS case number 275 of 12/9/2010, under section 40 of the IPC. Invitation regarding intimation regarding arrest of Ramchandra Mahapatra, son of Vasudev Mahapatra, Saripur, PS Pipuli district Puri, at present hostel superintendent of the Brahmapitra Sanic School, Bhubaneswar. On the writing report of the complaint, Sushant Kumar Behera, Sahidnagar police station case number 275 of 2007 under section 440 of IPC was registered, and the accused Ramchandra Mahapatra has been arrested on 13/9/2010. I am the forwarded to the Honorable Court of Rejection, Bhubaneswar on 13/9/2010. The copy of the FIR is enclosed here for your reference. This is for forwarding and information to necessary action. This has been intimated after receiving this intimation. The report has been issued to the petitioner respondent, but not communicating the arrest of the petitioner.
So the main, we have gone through the Impunj judgment. The main reason as has been assigned that whatever adverse was there against the respondent, that has not been communicated to him.
That exactly
some decision has been relied upon the Honorable Supreme Court that the uncommunicated, what would be the effect of the uncommunicated adverse report or entry, and That is how it has been held. You come to that specific paragraph.
That is the what my respectable assumption would be. That is the error on the part of the record
past
single judge.
performance. Yes, if you say it is error of record, it's all right. Paragraph number 15
My lord,
of that impugned judgment,
my lord.
which is running internal page is 14, running page is 50.
My lord, my lord.
So the last 5-6 lines of paragraph number 15,
My lord.
that is relevant, that nothing has been placed on record to indicate that any past performance report
My lord,
or past service record had ever been communicated to the petitioner. Action taken on the basis of uncommunicated materials available against the petitioner cannot also sustain in the eye of law, as the same is in gross violation of natural justice. He has relied upon the cases of Gurdayal Singh Fiji, that is in the page number 51, running page, internal
Yes,
page
yes,
is
well, but
15.
so
that there is no dispute about the proposition. The question is that if whether it is you say that it is an error of record or
because the communication has been made. That is the reason I read out to your lordship that counter affidavit para 6 and subsequently the
no paragraph 6 re counter court कहउछन communication विषय
the sir, your lordship may kindly see again, your lordship may kindly see. But that is the reason we have filed all these documents to show that all has been communicated.
No.
Your lordship may kindly see. And that is
counter that preliminary counter.
प्रिलिमिनारी काउंटर रे कोठी देखैचंती जे एतिको इ हला त कम्युनिकेशन जो लाइट रे इम्पुन जजमेंट ता पास है
my lord, that the averment of
paragraph
para 6 at page 33.
Let us come to that paragraph
33 para 6 page 33. I'm reading, that the averment of para 4 is incorrect and denied by the opposite party. The records of the petitioner maintained in the Sainik School Bhubaneswar reveals that during his tenure as a substitute superintendent, he was served with advisory notes, counseling note, warning, etc. for indisciplined activities, declaration of duty, doubtful integrity, lack of sincerity, deviation towards duty, etc. In this context, it would be worth mentioning here that the chairman, Local Board of Administration, Sainik School Bhubaneswar, who is authority for general administrative supervision of the school, he made the following observation about the petitioner, his general activity during May 2001. Having perused the recommendation of Sri R.C. Mahapatra, Hostel Superintendent Parawise comments by the principal, Sainik School Bhubaneswar, and recommendation of the commander, B&O sub area, I am of the opinion that the adequate opportunity has been afforded to Sri R.C. Mahapatra to improve his performance by frequent counseling by the principal, Sainik School Bhubaneswar. It is evident that in spite of such repeated counseling and warning issued by the principal, R.C. Mahapatra has been not improved his performance and conduct. To constitute the counseling and the warning letter issued by the principal as a harassment and torture as alleged by the petitioner is completely distraction of the actual event. This is the observation made in 2011, and we are.
No, this observation is to be communicated.
Yes,
but
that
it is not that you have made
that he was served with the advisory note, that specific lordship, and that is the reason we all this has been filed under annexure flag C and the flag E. Flag E is all the communication has been received. You lordship may kindly see. This is the all the service entire service record that has been annexed to flag C.
कारण आपण जो कहउछन ताकू एमती एडवाइस दिया गला आपण ताकू ये देले but what it requires that the advice is something different. What it says that past performance report or past service record सेटा जाकू होल्ड करचंती has never been communicated. आपण जदी गोटे फाइंडिंग आसिला ता अगेंस्ट केबे आछंती, that is to be communicated, not that तमे या करो से या करो. That's a is there not any difference between the two? जणु कहबते तमे या करो, but if you give a finding against him, whether that report is to be communicated to him or not.
Yes, ma'am.
So
that is the reason. One, that record has been called for by the Honorable. You will also may kindly see that is the reason all this flag C and flag E we have been filed to demonstrate.
All right, we'll continue it. Continue. Since tomorrow and day after tomorrow is holiday, so we'll continue it.
You will also make
28.
further hearing.
Natural continue man type
28 we do not know what is it.
Okay, no,
It's all right. Next date रे जेबे हबो bench.
that he will give. Next letter we'll get it from him. Yes.
चलो देखिए
Data बुझीजिए. Next data बुझीजिए.
May I please, my lord, in this case, the appellant has been convicted for life and for offense under section 302 and other offenses, all the punishments gone concurrently, my lord. The findings 110, sentence is running case 110, my lord. Yesterday,
4% face trial.
my lord,
And how many of them have been found guilty?
all are found guilty, my lord.
So they have preferred separate appeal.
My lord, yesterday one appeal was a criminal
Admitted.
appeal. My lord. That is
number
218 of 2025, item number 3, last question.
TRLA
218 of 2025.
2025.
My lord.
ତାଦେହରେ appellant ନା କଣ?
रंजीत कुमार जेना, my lord.
Ranjit Kumar Jena, acha. Bengo alias Ranjit Kumar Jena.
My lord.
218 na?
My lord, 218 of 25.
FIR details Raj.
Admit could be. Admit. Call for the the interim application so and so shall be considered after receipt of the empty litigant. It is stated that the co-accused Ranjit Kumar Jena has preferred
Bengo alias Ranjit Kumar.
Bengo alias Ranjit Kumar Jena has filed criminal appeal number 218 of 2025 challenging the interim judgment and order of conviction, and on 24 to 2025 this appeal has been admitted and trial court report has been called for. Since trial court report has been called for in the connected case, it is this matter along with CRLA number 218 of 2025 after receipt of the trial court record in this said case for consideration of the interim application for bail and stay realization on fine. In the meantime, deposition copy to be supplied.
Item 2.
25 na 24? Actually, 25 marla.
1/8 of 25 weekly. On conviction the Hochi पूर्वटा date of judgment होची 28/1/2025. So obviously it is
218 na?
218 of 2025.
देखा ही नहीं है तो ऐसा ना क्लियर हो पा रहा है GS ସେ କଥା କିନ୍ତୁ ଦେଖୁଛି ତାର ମେସେଜ ସେହି ଦେଖୁଛି
এটা এনগেজ করো কাউন্সিল
হ্যাঁ।
ডিলে কোন করবো this jail criminal appeal in which the appellant no admission ପାଇଁ ଦରକାର ନାହିଁ notice ପାଇଁ admission ଯେ bail ଫାଇଲ କଲେ ଇଏ ହବ ତ ତାକୁ engagement ଆମେ କରିବୁ counsel କୁ appellant So, since the appellant has been sentenced to imprisonment of life, the delay in filing the jail criminal appeal is condoned or admit for the trial court record. Sorry.
What?
Mr. Jafrullah, you are engaged here as the counsel for the appellant. S.K. Jafrullah for the give your
he just asked you not the counsel for him at any time. No, I will tell you Katak case.
no
Katak case na koti kara Jharsuguda नहीं बेल फेल काले केतल करथियो नहीं तो
PR भंजदेव accused for counsel होचंती अन्नमान लेखा है
ठीक है
RK Srivas संस्वांची
ले चेंज
just give your enrollment number
and phone number
phone data the land counsel for the states shall obtain the wakalatnama of the appellant na अच्छी देइछन ସେମାନେ वकालतनामा देइछन अच्छा वकालतनामा को अपन fill up कर देबे the land Mr. Jafrullah is permitted to fill up the wakalatnama on record original येटा वकालतनामा जोटा अच्छी तो हां मगे कि ना ठीक এটা পেপারলেস এটি এটি যে
স্ক্যানিং এর কি বলা
স্ক্যানিং যে আছে
আচ্ছা
হ্যাঁ খালি এটা ফিল আপ করি অলরাইট
नहीं he can collect from the registry पुणी इथे काय मगे पेपरलेस जे द्यायची काय मगे काय collect from the registry fill up and file it
अच्छा you fill it before the registry registry packet thibo city
because we don't have any records here it is paperless yes
There is a prisoner petition.
to engage somebody let us see okay there's a noting all right Mrs. Afrala one moment
One services
good which is the
might go to page here has he asked for any counsel on his behalf
one service must engage service for some
कोड लिखा है जी
flag violation made
हाँ बड़ा अच्छी
21
मैंने अपन को मोर विनम्र अनुरोध
ତେଣୁକରି ମୋର ମକଦ୍ଦମାର ସମସ୍ତ କାଗଜପତ୍ର ଓକିଲ ସଦସ୍ୟ ସାଙ୍ଗକୁ ଦେବାକୁ ଚାହୁଁଛି
कहा बोलियो ना कोड लिखा है जी
ଲାଷ୍ଟ ଲାଇନ୍ ଫର୍ଷ୍ଟ paragraph ଲାଷ୍ଟ ଲାଇନ୍ flag boy
ସରକାରଙ୍କ ତରଫରୁ ଓକିଲ
ମୁଁ
ସେଥିପାଇଁ
ଜଣେ ଗରିବ ଲୋକ ଅଟେ ତେଣୁ ଆର୍ଥିକ ସ୍ୱାଂଶ ଦୁର୍ବଳ ଅଟେ ଯାହାର ପାଇଁ ମୋର କେସ୍ ପରିଚାଳନା କରିବା ପ୍ରାଇଭେଟ ଓକିଲ ଧରିବାର ଅସମର୍ଥ ଅଟେ ସେଥିପାଇଁ ଉଚ୍ଚ ନ୍ୟାୟାଳୟରେ ଆପିଲ ସରକାରଙ୍କ ତରଫରୁ ଓକିଲ ଯୋଗାଇ ଦେବାକୁ ଅନୁରୋଧ କରୁଛି ନା କୋଉଠି ଅଛି କଣ
flag boy this is dated
କୋଉ କେସ୍ କଥା କହୁଛନ୍ତି ଏଇ ଆଇଟମ ନମ୍ବର 2
where did you find flag by
we are in item number 2 madam JCR
sure different so like he has given a prisoner's petition but no name
has been
Yes.
all right
हाँ
and this should be communicated to the appellant regarding the engagement of counsel yes
Item 3. May please, my lord. The file an IA for interim bail of appealants in CRL number 57 of 2019 models. There's a marriage of his brother, my lords, on 2nd March.
In the morning, you would have got instructions.
କେବେ ବାହାଘର?
2nd March, my lords, Sunday.
And he didn't know till when did you file it?
My lords, it's filed on
11/2 you filed it.
my lords.
So why are you not
11, my lords,
Aguru
it was
mentioned
mentioned, but could not be listed. my lords.
No, but once not when you should have mentioned till it was listed, because this is a marriage urgent and all these holidays are intervening.
ନିଜ ଭାଇ ନା କଣ cousin brother କି କଣ ସେମିତି?
Cousin brother.
Yeah.
And my lords, during the period of his custodial detention, he has already been released 5 times on parole, my lords, and he has never violated
No,
any
that is not a, that's a different thing, but
Earlier, he had given some forged document.
my lords.
Yes.
which is that order?
Order dated 12/8/2020.
12/8/20.
Yes.
No, you have to obtain instruction. IN number so and so. This is an application for bail on the ground of marriage of the brother of the petitioner, which is stated to have been fixed on 2/3/2025. Marriage invitation card has been annexed to the interim application as annexure 1. Let the land council for the state obtain instruction on the averments taken in the interim application, also the authenticity of the marriage invitation card. Put up this matter on 3rd of March 2025.
My lords, the marriage would be over by
ମ୍ୟାରେଜ ସେଇଦିନ ସରିଗଲେ ତାପରେ ଅଛି ଅନ୍ୟ ସେଦିନ ବାହାଘର ଅଛି ତାପରେ ଅନ୍ୟାନ୍ୟ କର୍ମ ସବୁ ରହିଛି। ଭାଇ ବାହାଘର ତ
my lords.
ଭାଇ ବାହାଘର ତ କଣ ସେଇଦିନ ସବୁ ହେଇଯିବ।
Reject ହେଇଛି on 1/2/2023. According to Indian National Law, but 1/2/2023 bail has been rejected. Point out on
May I produce the custody certificate?
No, for this application, no custody certificate is required. If you file on merit, that's a different matter. But when the कहाँ अगर पंचानन so and so डेट दिया ही नहीं आधे रे।
My lords, it is there.
हाँ
My lords, in page 3, annexure 1,
हाँ
the date is at the very bottom. My lords.
हाँ नहीं अच्छी है तापर प्रोग्राम टा देखो।
My lords,
हाँ
it is all on 2nd March.
तो 2nd मार्च कौन सब सरी जीवो।
My lords, it starts at 7:30. My lords, in the morning.
Yes, next.
Item 4.
File interim application for stay realization of file whereas
A prisoner's petition has come.
come and then
Flag D for engagement of so in place of so and so. You have filed Vinama. So any order has been passed in accepting the prisoner's petition.
No, the
prisoner's
first time
request.
after admission,
Acha.
first time it has come. After admission, it was not.
You have filed your Vinama.
Yes, my lord, I have filed.
It peruse the prisoner's petition at flag D, wherein request has been made for engaging Mr. S.K.Sahoo as his advocate. The prayer made in the prisoner's petition is accepted. Mr. Jafrullah has also filed his Wakalatnama. This is also accepted. The name of the earlier engaged counsel, Mr. P. Ramakrishna Patra, shall not be reflected in the cause list and play. Yes, what do you want further?
I filed an interim application for a stay realization of fine and a for bail.
Yeah. Your bail application has never been rejected
Never.
earlier.
Admission for a kebe, I've seen kebe.
Seen. Yeah, right. So here, what is the conviction and what is the sentence for?
Malata is convicted under section 302 IPC and sentenced to sentenced to life imprisonment.
Jail criminal appeal, have you got the that deposition copies?
Okay. Paper book is there.
Oh, paper book is there. Paper book is there. Achha.
Sorry.
Five is the doctor.
Five, my lord. He found
On the parotid region. Fracture of this.
one external injury, but there is internal damages are there.
Internal damage. Fractures are there.
Fractures of mundars of.
What is the motive behind?
Motive hochi previous day there is a dispute regarding partition of the property, land dispute thila. That is why.
No, how the appellant is related to the deceased.
So there PW3 paragraph 1. He stated that the informant is my elder brother. The deceased was my grandfather. I know the accused who is my paternal uncle. And गाँ हिसाब tar uncle habo. And he stated that.
So who are the eyewitnesses to the
PW 1, 2, 3, my lord. 1 and 2, they are brothers, two brothers. They were present.
1, 2, and 3 eyewitnesses.
Eyewitnesses.
And the doctor is PW 4.
PW 5.
5 is the doctor.
And IO PW 6. PW 4 is the.
So you are in custody for how many years?
My lord, more than 8 years, 17.
Since when you are in custody?
28/7/2016. 28/7/2016. 8 years.
You are never released on bail during trial?
No, my lord.
Accused is produced from jail.
From custody. Then convicted.
Eight years, 6 months.
8 वर्ष 6 मासर अधिक
All the eyewitnesses have
Yes, my lord,
constant
categorical they have stated that
that blow was given by you by means of that.
no other accused. I have given the blow on the head, and they have in the evidence they have stated that the two blows. First, I has assaulted on the head, then I would have done another blow on the neck.
PW2 stated that earlier on 23/6 there quarrel between the
PW2.
Yes. There is a quarrel.
ତା ପୂର୍ବ ଦିନ quarrel ହେଇଥିଲା.
ଆଜ୍ଞା ଝଗଡ଼ା ହେଇଥିଲା ସେ partition property କୁ ନେଇକି ସେ ତାକୁ ଧମକ
I heard that there was a quarrel between the accused and the district wherein the accused had threatened the district to kill in life. On the date of occurrence at about 8 AM, while I was in front of my home, so the district proceeded towards the jungle for the purpose of guiding, but started to return to village after seeing the accused standing at the end of village. While the district was returning, the accused came from his behind by holding a finger and assaulted him by means of a finger on his head. As a result of which
କେବେ ଡେ ଥିଲା ତାର କେତେ ଦିନ ପରେ
same day ରେ my lord.
କାରଣ ଗୋଟେ ହସ୍ପିଟାଲ
ରାତିରେ 12:30 ବେଳେ
ପ୍ରଥମେ ଗୋଟେ କଣ ହସ୍ପିଟାଲ କୁ ନେଲେ କୁମୁଲିପୁର ତାପରେ ଏସଡି ହସ୍ପିଟାଲ ଜୟପୁର ତାପରେ DHS କୋରାପୁଟ କୁ ଆଣିଲେ ସେଇଠି ବୋଧେ
ରାତି 12:30
while undergoing treatment at DHS Koraput. What about the criminal antecedent?
No, my lord, ନଥିବ ସେଇ ତାଙ୍କର village dispute ରେ ନା ତାର property dispute ଥିଲା regarding that is come my lord in the evidence. My lord, PW3.
A property dispute ଜଣା ପଡୁଛି ଯେ
ଆଜ୍ଞା paragraph 4 ରେ PW3 ର
PW3
paragraph 4 ଆଜ୍ଞା paragraph 4 on the previous day of the incident there is a quarrel between my grandfather and the accused with regard to a dispute about partition of land.
So that quarrel was at the spur of the moment or before, and so you came with that motive?
Spur of the moment ରେ ନାହିଁ ସେ ଆଗରୁ ଥିଲା ସେଇଥିରେ ସେ କହିଥିଲା ମୁଁ ମାରି ବୋଲି ଗାଁ ମୁଣ୍ଡରେ ଲାଠି ଧରିକି ଠିଆ ହେଇଥିଲା ସେ ଡିସି ଯେତେବେଳେ ଗଲା ତାକୁ ଦେଖି ସେ ଫେରିଲା ବେଳକୁ ସେ ପଛରୁ ଯାଇ ଗୋଟେ
PW1 and 3 have stated.
ପଛପଟୁ ଗୋଟେ ମୁଣ୍ଡରେ
PW1 and 3 have stated, no?
1 and 3
two blows ପାଇଁ evidence ନାହିଁ ଗୋଟେ blow ଆସୁଛି
FIR is also regarding one blow.
Yeah, PW2 says that ମାରିଲେ ସେ ବସିଗଲା ଆଉ ଗୋଟେ blow ଦେଲେ
ଆଉ ତାର ବେକରେ
ଅଛି
ଆଚ୍ଛା
PW5 ହଉଛି ଡକ୍ଟର
mouth of the deceased until 12:30 PM. Incident was କୋଉ time ରେ
8 AM ସକାଳ
so ମରିଲା same day at 12:30 PM.
DHS କୋରାପୁଟ ଡକ୍ଟର ହଉଛି PW5 ଡକ୍ଟର
PW3 also stated that
three-sided fracture ଅଛି.
while my grandfather started
One lacerated wound parietal region right side of the scalp, another fracture on the left side.
That is internally. Externally good. Internally ଦିଟା ରହୁଛି ତାର corresponding internal fracture ରହୁଛି skull but
skull ଅଛି ଆର ପଟେ ଗୋଟେ ଅଛି ସେଟା ଛୋଟଟା not that ଯେ ଏକାଟା ଯାଇଛି this is another that is another
ଏଇଥର injury କିଛି ଆସୁନି
Doctors say that the injury found to the deceased could be possible by means of bamboo stick.
No, that is intracranial hemorrhage is mundre adhesis jaha jana pauchi property dispute and doctor has also given the opinion that this injury is possible by that thenga da produces
that opinion is under exhibit 7.
So there another
the state seeks some time to obtain the instruction regarding criminal antecedent of the petitioner if and put up this matter. Good day, Mr. Ratho. Yes.
Item 5.
Please, my lord. I mean VC, my lord.
Yeah.
On behalf of Prakash Prida, my lord. Lordship, on the last occasion, the Learned Counsel for the state took time to produce the custody certificate, Lordship. But it is already there by order dated 30th of January 2025, my lord. The custody certificate in respect of present appellant is already there in the appeal. It is 8 years, 9 months, 30 days, Lordship. Order dated 30th of January 2025.
Last वर्षी कस्टडी এটা কেবেকার কস্টডি সার্টিফিকেট 9/12/2024 আছে 9/12/2024 ରେ ରହୁଛି period ହଉଛି କେତେ ବର୍ଷ ABC
30th January
8 ବର୍ଷ 9 ମାସ 13 ଦିନ ମାନେ ଆଉ 2 ମାସ ଅଧିକା ହେଇଥିବ ତାହେଲେ 8 ମାସ 8 ବର୍ଷ 11 ମାସ ହଉଛି କଣ ଆଲିଗେସନ କଣ ଅଛି ଆଗୁ ରିଜେକ୍ଟ ହେଇନି
No, man.
So, in this criminal appeal, you are moving in bail application in CRLA number 225.
Yes, my lord.
How many appellants are there? Prakash Parida is the sole appellant.
No, other appellants are there also, lord.
No, my lord, in that case, bunch of appeals are there.
No, he is moving for one appellant, but that is Prakash Parida, CRLA number 225 of 2020. You are in the second item.
Yes, sir.
ଆମେ ତାଙ୍କଟା ଶୁଣି ସାର୍ ଆପଣଟା ଶୁଣିବି CRLA 225 of 2022. Appellant name is Prakash Parida. So, what is the prosecution case?
That's the case of the prosecution is that while the receipts were returning from the market, the accused persons in furtherance of their common intention of assaulted him, uprooted his left hand and thereby attacked him by means of weapons for which he succumbed to the injuries, lordship.
Eyewitnesses are there.
No, my lord, no eyewitness, only one info, no such eyewitness is there, lordship.
Eyewitness ଅଛନ୍ତି ନା ନାହିଁ? Mr. Mahanti.
Yes, yes.
Who is the eyewitness?
Sir, in the time scan me. और तो पेपर बुक था फर्स्ट अपील था देखा तो मुझे नहीं फर्स्ट सर पेपर बुक का स्कैन
For book and TCR is not available, sir. I am
available means they have not, it is available but they have not scanned it. Noting says it is there but it is not
Second item re
Not in the second item, prayer for interim bail for 3 months.
Wait. Second item ko bola.
Oh, same जब ये trial why are they giving two separate paper books? ଆମ ବେଳେ ତ ଏକାଟା ଦିଅନ୍ତି ନା ଦିଟା ହବ ସେ କଣ ମୂଲ୍ୟ ତାର
Paper book ଟା ବାହାର କର second item ରେ ଅଛି. Item book ଟା ଦେଇଛି. First ରେ ନା second ଟା ଦେଇଛି.
नहीं second ଟା ରହୁଛି noting but
My lord, in the second item, it was a split of trial, my lord. Is the sole accused in the
split of trial.
Split of
It's all right. Then it's all right. All the more reason the first one they should have provided.
That's
ଏଟା trial number ଅଲଗା ଅଛି
ତ ଆପଣଙ୍କର ତାହେଲେ ଇଏ ସ୍ପ୍ଲିଟ୍ ଅପ୍ ହେଇଛି ମାନେ କଣ ମାନେ ସେ ସାକ୍ଷୀ ଗୁଡାକ ନମ୍ବର ବି ଅଲଗା ହେଇଥିବ
number भी अलग है.
ତାହେଲେ ଆଉ କେମିତି
4 to 5 trials are there.
abscond କଲେ ନା କଣ
So later he was arrested.
ହଁ ମାନେ ସେ
So,
Four, 5 judgments, your lordship. In one day judgments were delivered, but 3 to 4 trials are there.
3 to 4
judgment देखिला हो judgment
Lordship, paragraph 6, Lordship. The eyewitnesses are PW 1, 5 and 12, my lord. Paragraph 6 of the judgment, Lordship.
wait Mr. Sahu, in your appeal the judgment is passed in ST case number 24 of 2019.
Yes, sir.
And you are the single accused in that case.
Single accused.
Why you said that number of appeals have been, number of ST cases have been disposed of in that?
Yes, your lordship. That is my instruction. Actually, my lord, all these appeals were tagged in previous dates, and
it cannot be tagged. You see, if the ST case numbers are different, witnesses numbers are different, it cannot be tagged, because they may, one witness might have stated against you, and if he is examined as, let us say, PW1 in your case,
yes, sir,
he may be examined as PW5 in the other case. So
yes,
some lines may be different also. He might have stated against you, but in the cross-examination will also be different, because that is by a different counsel. So how it can be tagged together and
my lord, all those judgments were delivered in one day. That will
Obviously, argument different, different, so maybe different. Incident.
My lord, under different judgments, cases have been disposed of, but in one day.
ठीक अच्छी किंतु सेपरेट जजमेंट ही थी वो
सेपरेट जजमेंट
सेपरेट जजमेंट हेले सेपरेट क्रिमिनल अपील हबो एवं क्रिमिनल अपील जजमेंट मध्ये सेपरेट हबो कारण PW1 होइया समान नहंती ना आर यू
right your lordship. In one judgment, so far as I remember, one Sukadev is there, 4 accused persons were there in that case. And in this case, one. In my brother's case, my lord, that is also.
That is why we are taking off individually. ये जो मैटर कहउछंती प्रथम रे हमें टेक अप करजु CRLA number 225 of 2022.
One thing I may suggest, my lord,
Yes.
different cases. So ST 151 relating to 3 cases, ST 25 1 case, ST 113 2 case. So ये 4 टाइम पे टेस्टर टोटल लिखी
नहीं चार्ट में पेपर बुक भी तैयारी नहीं परा दे
नहीं फर्स्ट टाइम को तैयारी है जे स्कैन है
उठा
दुकुलांदे नोटिंग रे अछि पेपर बुक पड़े
এটা হচ্ছে ফার্স্ট টাইম
এটা তো
ফুটনোট নিয়েছি
ମୁଁ ତ ଆଧାର ଖୋଲିଲି ଏଠି
ହଁ ଏଥିରେ এইটা ଯୋଉ ଅଛି পেপার
ଫିଟୁ ନେଇ ଗଲା
পেপার বুক ଓ ଏଟା ଖୋଲୁନି ଓ ନାଇଁ ଏଟା ତମ ସ୍କାନ ହେଇନି
ଆଉ ତ ଜଣା ପଡୁଛି ଅଛି ଏଟା ପେପର ନେସନା ରେକର୍ଡଟା ଅଛି ଆରେ ରେକର୍ଡଟା ଅଛି ଦେଲେ କ୍ରିମିନାଲ ଅପିଲ 225 ର ରେକର୍ଡଟା ଦିଅନ୍ତୁ କ୍ଲିୟର ହେଇଯିବ ନା ସେ ଯୋଉ ହେଇକି କହିଲେ ଏଠି ଯେ କହିଲେ ଏଟା ସେ ଡିଲିଂ ଆସନ୍ ତ ଦିଟା ବିଲ୍ ଆପ୍ଲିକେସନ ଅଛି ନୋଟିଂ ଦେଇନି ତ ସେଟା ତାଙ୍କୁ କହିବି ଗୋଟେ ମୁଁ ଅର୍ଡରଟେ କରିଦେବି ସେ ଦେଇଦେବେ ଯେ ଆଗଟା କହୁଥିଲି ତା ଦେହରେ ଅର୍ଡର କରିଛନ୍ତି ଯେ ସେ ତା ଦେହରେ ବିଲ୍ର ନୋଟିଂ ଦେଇନି I thought he would he has placed correctly, but our dealing assistant had not given the noting of the IAs. Only would interim bail with him. 177 ସାଙ୍ଗେ ବନ୍ଧା ହେଇଥିବ ଦେଖନ୍ତୁ 225 225 ଫାଇଲ ନାହିଁ
ଦଉନାହାନ୍ତି 225 पेपर बुक दियନ୍ତୁ
ଅଛି ସ୍କାନ ହେଇନି
ଏଇଟା
ହଁ ଓ ଏକା ସାଙ୍ଗେ ହେଇଛି ଗୁଡ
ନାଇଁ
ହଁ
this is 177 177 is a separate session
ଓହୋ ତାହେଲେ ଏଇଟାର ତିନିଟା
ଏଇ session style ରେ
ସେଟା ତିନିଟା ଲିଷ୍ଟ କରିଦବା କଥା ଏକା ସାଙ୍ଗେ
ହଁ ଏଇ ତିନିଟା ଇଏରେ ST case number 151 ଆଉ ST case number 220 ଏଇ ଦିଟା ଯାକର କମନ ଜଜମେଣ୍ଟ ହେଇଥିବ ଆଦେରେ
এটা নো এটা 225 তো হ্যাঁ ঠিক আছে
এইটার কমন জজমেন্ট ହେଇଛି
ଏଇଠି ଦେଇଛି with criminal appeal ତା ଭିତରେ ପୁରେଇଛି 154 ମାନେ ଆଉ ଗୋଟେ ଆସିଲେ
225
and you see
178
ଆଉ ଅଛି
ତିନିଟାକ ରିଲେଟେଡ ଟୁ ST
ଆଉ criminal appeal 154 criminal appeal 178 criminal appeal 215
that in the
you see this PW.
That is natural. Obviously, alga prior hele se jetala asibe alga heki na. Ha.
154
Are maybe se eka PW hele bi kahithu abo na.
So that is we have to hear
150 relating to ST 113.
Oda?
One criminal law 150 for 2022. That ST 113.
Bole ethi kon pe eka sange jodi ki dela order thibo.
When you mention the other connected accused person are filing, that's why it has been there.
Clear kar dela hobo je ei tare is indirect.
So who are the eyewitnesses in your case, Learned Counsel?
Lordship PW 1, 5 and 12 my lord.
What they have stated against you?
Lordship PW 5 has stated on
When you come to PW1, why you are going to 5? PW1 kon basic hoichi ki apna na?
na lordship kisi na
your interim bill kon pai file karchandi? Mr. Sahu?
My lord, on the ground that the wife of the appellant was ill and is
Have you taken instruction?
So because the IO is transferred, the other information provided only the information on the health condition that is not.
That specifically we need an interim application. If IO is transferred, then all come the police station and stops.
No, IAC is not there. That's why he paid for only 7 days time. Last occasion that the health condition report was called for.
Your name find place as an assailant. Land Council. This man, Prakash Parida.
Yes, my lord. It is alleged that he has assaulted the left leg of the deceased, my lord.
I saw so and so, so and so. We are going, we told so and so.
Page 11 of the judgment.
Prakash Parida was holding a sword.
Yes, my lord.
And they were chasing Babuli.
Yes, my lord.
Assaulting to his legs. So you have given the sword blow on the leg. Then that man fell down. The deceased fell down on the ground. Then one of the accused, he sat on the chest of the deceased and he took a knife from the hand of another person. Then he removed the left eye of the deceased with that knife.
Yes.
And also assaulted on the right side eye. गोटे आखि आपण ताड़ी देले मारिकिनी तापरे so this is the way you have assaulted.
No, Lordship, Basanta Sitha has removed the eye.
This 34 is there and it's a conjoint assault. Apona godare khondare hani dele se podi gala ଅନ୍ୟ ମାନେ ତାକୁ ଖଣ୍ଡାରେ ମାଇଲେ ତାପରେ ସେ ପଡିଗଲା ପରେ ଜଣେ ତା ଛାତି ଉପରେ ବସିଲା ଅନ୍ୟ ଜଣେ ଛୁରୀ ବଢେଇ ଦେଲା ତାର ଆଖିଟା ତାଡିଦେଲେ ଲେଫ୍ଟ ଆଇ ଏଟା ହଉଛି କେସ୍ ଏବଂ କରେସ୍ପଣ୍ଡିଂ ଇଞ୍ଜୁରିଜ ଆର୍ ଦେୟାର Since when you are in custody? Prakash is in custody since 27 to 2016. You are taken into custody.
ST Academy.
Yes, sir. Babuli Bantha is that.
They assaulted the deceased by means of these, and the deceased fell down on the ground.
Holding.
IA number 452 of 2022. This is an application for bail. The learning counsel for the appellant submits where the appellant is in judicial custody. Final front of the since since 27 to 2016, and PW1, PW5, and PW12 are the three eyewitnesses to the occurrence. But so far as the petitioner is concerned, the overt act that has been attributed against him is that he assaulted on the leg of the deceased by a sword. The main allegation has been labeled against who accused Basanto Sitha, who stated to have snatched away knife from the hands of accused Bhagavan and removed the left eye of the deceased with that knife, and also assaulted to the right side eye of the deceased. He submits that since there is no chance of early hearing, therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of the eyewitnesses. So also the evidence of the doctor who has noticed number of incised wounds on different parts of the body of the deceased and opined the cause of death was due to craniocerebral injury involving brain-like vital organ. Considering the submission made by the learned counsel for the respective parties, the evidence of the eyewitnesses and the doctor who conducted the post-mortem examination, and the manner in which the crime has been committed, we are not inclined to release the petitioner on bail. Stands rejected. You, in this interim application, you obtain instruction. IA number secondary लिखिए देखो तो CRLA number 177 of 2022 तादर उटा interim bail अछि. IA number 3375 of 2024. There is an application for interim bail on the ground of ailment of the wife of the petitioner.
Time.
अच्छा होता है या अच्छा
Twice you have been given time.
Yes, yes, that's right.
the land council for the state time केबे रखिबा कोंतो दिथर land
1 week after.
1 week for
I
the
have
time
talked with the consultant.
to obtain instruction on the interim application put of this matter in the convention from 10th of March 2025. Yes.
In the case, I am informed.
Yes.
In the both case, I am informed.
Acha, Mr. Amitabh Tripathi on
Yes, yes.
Mr. Amitabh Tripathi, land counsel for the informant is present. Perform the duty reject the law. Here. Thank you.
The IAC is also present.
12.
हो हो
12. IAC.
ଏଟା ଆଗରୁ ମେନସନ କରିଦେଇଥିଲା ଯେ ଜଲ୍ଦି ଉଠିବାର ଅଛି ନା ଗୋଟେ ଟେକିଂ ଇଟ୍ ଫର୍ଷ୍ଟ ଏନିୱେ
On it, you know.
Instruction. I have already received the instruction matter. Yeah, IAC.
Item 12.
yes why was he not responding to the your
Where is the
request?
IAC?
That is why we have called him. Where is he?
टाउन थाना सर
हाँ
कौन ना कौन हो?
सर प्रभांशु शेखर मिश्र सर
हाँ?
प्रभांशु शेखर मिश्र सर
प्रभांशु
सर
शेखर मिश्र
सर सर
केबेठु आईएसी रहिलानी भद्रक टाउन पुलिस स्टेशन रे
16 तारीख जॉइन कली सर 16 फेब्रुआरी जॉइन कली सर
16 फेब्रुआरी
सर
आ ए जो एडवोकेट जनरल का ऑफिस रु जो सब चिट्ठी पत्र जाउची तार कंप्लायंस करनांती काई किसी रेस्पॉन्स करनांती
सर सर जानि नथली सर 19 तारीख दिन पाइली तार 19 तारीख दिन सर मेल करथिली सर किंतु सर टिके डिले ही गला सर ता वेरीफाई करके मेल कला बेलको रेकॉर्ड खुजी कि ये कला बेलको सर
और एबे इमीडिएटली जहां जिबे कारण किए बेल किए कौन इंस्ट्रक्शन पई आपन मगाउथिबो क्रिमिनल एंटीसीडेंट तो इमीडिएटली रेस्पॉन्स करिवे हला
सर सर
लेखंतु दी
ଆପଣଙ୍କ ପୂର୍ବରୁ କିଏ ଥିଲେ ଆଇଆଇସି
से अजय बागे थे इंस्पेक्टर अजय बागे थे मैडम
ଅଜୟ ବାଗେ
मैडम
the in pursuance of the order dated 19/2/2025 Mr. Prabhanshu Shekhar Mishra, the inspector in charge of Bhadrak Town Police Station, is present through virtual mode, and he stated that he joined as IIC on 16/2/2025. The London Council for the state has produced the written instruction received from the IIC to the effect that there is no criminal antecedent against the petitioner, and he has also submitted the copy of the notice served on the informant,
Victim and
victim and the informant.
victim ଟା class 9 ରେ ତାକୁ ଯାଇକି ଦେଇଛନ୍ତି
ପୀଡ଼ିତାଙ୍କ ସହିତ କଣ ଦରକାର ପ୍ରଥମ the notice, the documents are taken on record. The matter will be listed next week for consideration of the bail application. Personal appearance is dispensed with for the
outer line जोड़ दो कि he has joined on 16/2
हाँ लिखिली परा रखी देछि तांकर ए जो नाटा स्पेलिंग टा ठीक से कहिन करिवे देबे
नमस्कार